All right. Sound check.
Good morning, everybody. Welcome to the Assembly Committee on Judiciary. Madam Secretary, would you call the roll?
Assemblyman Anderson. Here. Assemblyman Araujo. Here. Assemblywoman Diaz. Here. Assemblywoman Fiore. Here. Assemblyman Gardner. Here. Assemblyman Jones. Assemblyman Nelson. Here. Assemblyman Orenthal. Here. Assemblyman O'Neill. Here. Assemblywoman Seaman. Present. Assemblyman Thompson. Here. Assemblyman Wheeler. Here. Chairman Hansen.
Here. Who are we missing? Just Mr. Jones. We'll mark him present when he arrives. All right, folks. Rules of the road for today. If you have a cell phone, make sure that it is turned off or in silent mode or anything else that makes noise. If you intend to testify today, be sure you signed in, and that if you represent an organization, that you present a business card to the secretary. If you want to have exhibits given to the committee, you have to provide 20 copies to the secretaries who will distribute them. If, in fact, you wanted them for this hearing, they needed to be turned in by noon the day before the hearing. Decorum is critical. This is a very volatile issue. Actually, we have two bills actually we're going to hear. Etiquette is strictly observed here. There's no booing, no clapping, no cheering. So keep those kind of comments to yourself. Show proper respect to the people that may disagree with you. When you testify, be sure and state your name for the record. And when there are interruptions in the conversation, repeat your name. That's so the secretaries can keep the minutes. We are going to start on now, because there is such interest, especially in Assembly Bill 148, we are going to limit the testimony on Assembly Bill 140. We're going to stop the hearing on 140 at 8:30. Which gives the proponents basically an opportunity to present their case. We will then have an additional hearing on 140 to allow the opponents of the bill an opportunity to present as well. I apologize for that, but as you can see, there's a great deal of interest in 148. And the plan on that, just so you know, I'm going to allow the bill sponsor to talk, and then I'm going to allow 9 people who they have listed to speak as proponents of the bill. Then I'm going to give 9 slots for the opponents of the bill. The opponents will actually start off, and this was a request from Chancellor Dan Claich, with former Attorney General Catherine Cortez Mastos, who is going to lead off the opposition. Then I will rotate to make sure it's fair to everybody. 3 and 3, three opponents, 3 proponents, and so forth. We will go till 11 o'clock today if necessary. At 11 o'clock, though, this meeting will shut down. So just so everybody understands, I'm trying to give everybody, because we've got hundreds of people that actually are interested in this bill that want to testify, and I'll have about 2.5 hours to try to accommodate you as much as I reasonably can. Also, if a testimony has been given that basically agrees completely with yours, you can do a me too or a ditto if you want to just get your name on the record too, to try to facilitate the opportunity for everybody to participate. With that, we will open the hearing on Assembly Bill 140, which revises provisions governing certain domestic relation matters involving veterans with service-connected disabilities. And it will be presented by Assemblyman Jim Wheeler.
Mr. Chairman, thank you for the opportunity to present this bill, or represent this bill, I should say. For the record, I'm Assemblyman Jim Wheeler, District 39. This bill was brought forward actually 2 years ago, and we brought it back because we think that after hearing it a couple years ago, that maybe it still has some good validity, and we feel the bill is important enough to bring back. What this bill does is it puts us into compliance with federal code, which is, let me find it here, Chapter 11 of Title 38 of the U.S. Code. And basically, this bill is, I hate to say it's simple because it's, that is the curse, but it does put us into compliance with that. And what it says is, if you are a disabled veteran receiving disability pay, that during a divorce proceeding, that disability pay, or any civil action really, that disability pay may not be used in the calculation. You see, disability pay is not there as an income. Now, this bill does nothing with retirement pay or any other outside income, only the disability pay. And the reason for that is because disability is not an income. Disability, which by the way is not taxable, is there to make our veterans whole again. So in other words, if you have a veteran, be it a man or a woman, who has come back with a service-connected disability, they need this money to build a ramp, to have a wheelchair, to have a special vehicle. It gets them as close to being whole as they can possibly be. Therefore, what we've seen in the past, and there's been examples, and I'm sure there'll be some anecdotal information today with some of our presenters, where some people have actually taken advantage of this in Nevada and have married veterans and then soon after divorced them and got a piece of that disability pay, as well as their retirement or anything else. So the U.S. military, or the U.S. code, put a stop to that, and it's been in effect for years. And we're just trying to put Nevada into that code. With me today are Troy Yarbrough and Daryl Brown from the Disabled American Vets, and they are going to help me present this bill, so I'm going to turn it over to them.
Very good. Mr. Yarbrough, Mr. Brown, who would like to go first?
Thank you, Mr. Chairman. For the record, Daryl Brown. Members of the committee, appreciate the opportunity to be here today to speak on our behalf to support Bill AB 140. I'm going to read in the testimony. Our chairman, Mr. Caleb Harris, who sent information to the committee, is not available today. He's out of town, so he's asked me to sit in his place. I am a member of the United Veterans Legislative Council, and I'm the Government Affairs Chair for Vietnam Veterans America Nevada State Council. So if I may, Mr. Chairman, I will read this in Mr. Harris's voice as best I can. Good morning, Chairman Hansen and esteemed committee members. My name is Caleb Harris, and I represent disabled American veterans and the veterans of foreign wars for the state of Nevada. I'm also the chairman of the United Veterans Legislative Council, or we like UVLC. I apologize I'm not able to attend this meeting in person, but I'm currently out of state serving my DAV duties in Washington, D.C. Despite my absence, I'm hopeful that the committee will also take into consideration the veterans and their families I represent, as well as Title 38 United States Code, Section 5301, while deliberating on this bill. Disability compensation is a federally administrated program, and we believe it should be just that when considering this as compensation in a court of law. We request that our state adheres to the guidelines of Title 38 U.S.C. Section 5301. And now I'll turn it over to my colleague, Mr. Yarbrough, who will explain more about 5301.
Good morning, Chairman Hansen and members of the committee. My name is Tony Yarbrough. I represent the state of Nevada VFW, and I'm a member of the United Veterans Legislative Council. I want to read the actual code that says, it's first Section A1 of the code of 38 U.S. Code Section 5301. This is readily available on the internet in so many different forms, it's amazing. So it's out there and it's easy to reference. Number one here, it says payments of benefits due or to become due under any law administered by the Secretary shall not be assignable except to the extent specifically authorized by law. And such payments made to or on account of a beneficiary shall be exempt from taxation, shall be exempt from the claim of creditors, and shall not be liable to attachment, levy, or seizure by or under any legal or equitable process whatsoever, either before or after receipt by the beneficiary. Nowhere in this does it say specifically authorized by law that allows this compensation to be considered as community property. Nor does Title 38 state that a state judge should have the ability to disperse these monies at his or her discretion, which is the current practice in Nevada in many divorce proceedings. Currently, in the state of Nevada, the decision on how veterans' disability compensation is to be used and distributed in divorce settlements is left up to a presiding judge. While the state cannot garnish the veterans' disability compensation directly, judges are doing so indirectly after receipt, which is strictly prohibited in the above quoted U.S. Code. In Nevada, a judge can currently implement an order for such a payment. Upon the absence of payment, the veteran can be held in contempt. This can ultimately leave the veterans with two choices: pay the judgment or suffer the repercussions. In the worst cases, this results in jail time. This is definitely not in line with Title 38 U.S. Code 5301, paragraph A3A, which states, this paragraph is intended to clarify that in any case where a beneficiary entitled to compensation, pension, or dependency and indemnity compensation enters into an agreement with another person under which that agreement, such other person acquires for consideration the right to receive such benefit by payment of such compensation, pension, or dependency and indemnity compensation, as the case may be, except as provided in subparagraph B, which is a different issue, and including deposit into a joint account from which such other person may make withdrawals or otherwise, such agreement shall be deemed to be an assignment and is prohibited. That can't be any clearer. So, AB 140 will align the state practices regarding the veterans' disability compensation to Title 38, removing it from the consideration in community property settlements. The UVLC strongly supports Assemblyman Wheeler in his efforts to bring Nevada statutes in compliance with federal law. Thank you.
Thank you, Mr. Yarborough. Do you have anybody else up here in the north, Mr. Wheeler, that intends to testify in favor of Assembly Bill 140?
Mr. Chairman, I assume there's quite a few people that are going to testify in favor, but if you'd like to open it for questions to us before we leave the table, that's up to you, sir, of course.
Okay, well, we'll do that. For the committee members for today, you're going to be limited to one question, and follow-ups will not be granted because we want to give the public as much opportunity as possible to participate and let them express to us their concerns. So we even in this for this bill, this is proponents only at the moment, so if you have any questions now, it will be limited to one. Mr. Anderson.
Thank you, Mr. Chairman. Good morning, Mr. Wheeler, Mr. Yarborough. I'm looking at NRS 31045, and it makes clear, along with several other attachment provisions, garnishment provisions, that veterans' benefits are already exempt from execution. And so, I'm wondering about the need for this, because when you talk about awarding community property, which is what the statute that you refer to federally refers to, and to execution, those are separate concepts than awarding alimony. When you award, there's several stages in divorce. There's the awarding the different parts of the estate, the community property to the different, then there's the child support obligations, then there's alimony. And so the way I read this bill, this doesn't speak to community property. It doesn't speak to execution, because under Nevada law it's already exempt from execution. So this wouldn't affect awarding community property. This just affects alimony. So I'm wondering how this is the same thing as the federal statute. It doesn't appear to me that we're just codifying the federal statute.
Jim Wheeler for the record. Assemblyman Anderson, in Section 2, subsection 3, it says to award any other income or property of a veteran to the veteran's spouse or former spouse. Okay, and I believe that right there is community property. So, and that, at least that is the intent of the bill. And so we're trying to bring ourselves, you said, I'm sorry, I got to back up a little bit here. You said you wonder why we need it. Because we need it because time and time again, even though it's in federal law, it's courts in Nevada are awarding a veteran's disability to the spouse in the form of alimony. And to us, that is community property. Thank you.
See no further questions. I'm sorry, Ms. Diaz, go ahead.
Thank you, Mr. Chair. My question is, can you name a single situation or circumstance in which a veteran was jailed for not paying alimony under this clause?
Okay.
Ma'am, we can research that and get that information to you, if you'd like. For the record, Darrell Brown. Did I answer your question, ma'am?
Mr. Araujo?
Thank you, Mr. Chair. Mr. Wheeler, I just have a quick question, and just for clarification. If it's only confirming federal law, then why haven't they challenged the current practices that are in place?
Jim Wheeler for the record. Mr. Araujo, actually it has been challenged. It was challenged 2 years ago right here. It's being challenged today. That's what we're doing.
Okay.
Mr. Orenshaw?
Thank you very much, Mr. Chairman. And Mr. Wheeler, I appreciate what you're trying to do to try to make the disabled veteran whole. I just wonder about the scenario where maybe the veteran and the spouse are at a remote base. The spouse might have given up her career back here in the States to be with their loved one, and unfortunately, marriage goes south, and they decide to split up, and the spouse doesn't have the opportunities that they had back home before they relocated to that remote base, and they're trying to get back on their feet. I just wonder how this is equitable to that spouse, because that spouse made sacrifices for their loved ones so they could serve.
Jim Wheeler for the record. Assemblyman, you and I have kind of had this discussion before, and what we're trying to do here is we're not talking about any kind of retirement pay. We're not talking about any kind of current military pay. We're not talking about anything except the disability pay that makes the veteran whole. And that's all that is for. So when you're talking about, how does that person survive or whatever, there's other avenues for that. What we're looking at here is just the portion of the pay that he receives that is non-taxable, and it's non-taxable because it's not income. That's why it's non-taxable. Thank you.
Seeing no further questions, thank both. By the way, for the committee, we will have this hearing again, so we'll be able to more thoroughly vet this. But in the interest of time this morning, we're going to have to move things along. Are there three more people that would like to testify in favor of Assembly Bill 140 at this time? Here in the north? Seeing none, let's go down south. Is there anybody down there in Clark County that would like to testify? Oh, I got a couple here? Okay. Oh, I'm sorry. Pardon me. Good morning, both of you, and go ahead and state your name for the record and proceed.
Good morning. My name is Vicki Maltman, and although I am a non-paid lobbyist for veterans, I am also the wife of a disabled spouse, 100%. My husband turned 22 years of age on November 4th, 1966. On Thanksgiving Day in Vietnam, in a rice paddy, he was shot twice. The first one went through his shoulder, took a part of his lung, and his aorta. He suffers from the loss of the use of that hand, had major surgery, and was in the hospital between Walter Reed and a hospital in San Francisco for 2 years. When I married my husband, I knew his disabilities. At that time, the U.S. Army retired him, and he received approximately $300 a month. We're talking 20-plus years ago. It's been 40 years since he's been disabled. But I have to say, when I married him, I knew what his disabilities were. I knew what to expect, and I knew that it would never get any better. It would only get worse with age. I, as his wife, had my own career. I'm a retired police officer, and I do not need, nor do I expect, nor would I ever expect that if I chose to leave my marriage and my husband, would I be entitled to anything that he receives because of his wounds. I am not the one that was shot. I am not the one that suffered in a hospital for 2 years. I have my own situation. My husband puts up with me, and I put up with him. sometimes a lot more than he puts up with me. I do not feel, I will never believe, nor even if I were awarded, which I had an argument with a judge in Washoe County about this, who was not even aware of the federal law. And there have been other cases that have been turned over where it has been considered community property. It is not. That money goes to my husband, goes to any veteran, whether they be male or female, for the suffering that they do day in and day out for the service that they gave to our country. Thank you.
Thank you, Mrs. Maltman. Is there any questions for Ms. Maltman at this time? Seeing none, sir, go ahead and proceed.
Good morning. Thank you so much for being here today, and thank you for listening to this bill. My name is Steve Sanson. I'm the president of Veterans in Politics International. I have spoken on many bills before the Assembly, and 2 years ago I spoken on this bill. And looking at the audience, looking at you guys, some of you already talked to about this bill. This bill, the service-connected disability benefits is supposed to make the veteran whole again. It has nothing to do with a spouse. It has nothing to do with their choices that they make to be with that veteran. This bill only supposed to be used for the injuries that the veteran sustained. Now, I'm 80% disabled because of injuries that I received when I was in the Gulf War. And a lot of people that protest this bill never even served. A lot of people that protest this bill does not receive service-connected disability benefits. So listen to the person that received the service-connected disability benefits, because I have my injuries and the government is paying me. You know something? To even get service-connected disability benefits, do you know what a veteran has to go through to get that? It took me years to get my service-connected disability benefits. And it's not because I wanted it, it's because the government deemed necessary for me to have it because of injuries that I have. These injuries I live with every day. Giving part or even a portion of my service-connected disability benefits to an able-bodied spouse, where does that leave my injuries? Are you going to award my injuries to that spouse as well? If you cannot award my injuries to my spouse that I'm leaving, then leave my money alone. Because it's for my benefit. It's for my injuries that I received. And there's a lot of veterans that are very angry by this decision 2 years ago. And it's really heartening that the veteran has to even come before anybody and to say, hey, these monies are for my injuries. What are you doing? Why are you awarding it to an able-bodied spouse for? They're for my injuries. And last time when I testified, I said this. I said, if you cannot award those injuries, then don't mess with the service-connected disability benefits. I thank you so much for listening to me.
Thank you, Mr. Sanson. Seeing no questions, thank you both. Is there anybody down in Southern Nevada that would like to testify in favor of Assembly Bill 140 at this time? Seeing none. Anybody else here in the North? We will go to Ely. We have Ely today, interestingly enough. Hi, Ely. Is there anybody there who wants to testify on Assembly Bill 140? Seeing none.
There are no proponents here.
Thank you very much. We will put the hearing on Assembly Bill 140 into recess, and we will reopen that hearing to the opponents at a future date that we will let everybody know. Oh, well, we are, you know what, is that right? Okay, well, you know what, we are actually going to allow some folks in Ely. I apologize, I thought you were here for Assembly Bill 148. You would like to testify in opposition to 140 at this time?
Everyone here is in opposition, yes.
How many people are there that would like to testify?
3.
It's 3 today.
Nobody's in Ely for 148 then. I apologize. I thought you guys were there for 148. All right, well, I'll tell you what. I'm going to give 10 minutes to the opposition then because you're in Ely. And all 3 of you will get to testify. No questions at this time. Go ahead and state your name for the record and begin.
Good morning. My name is Melissa Exline. I am a family law attorney. I want to start by saying something because I think it's important for those there to know the perspective of where some of the family court practitioners stand. But for me specifically, I want to say thank you for having us and allowing us to testify remotely today as well. I'm the daughter of a veteran. My dad was a master sergeant in the United States military. He retired after 23 years of service. Much of that time was spent in the Special Forces, and he spent a lot of time in Vietnam. What that means to me as the daughter of a veteran is that I was strongly instilled with the value of love of country. I love Nevada, and I also want to say that I have a strong love and respect for U.S. military members and veterans. I can't say enough how much I respect veterans. But that said, I also practice family law. And with my perspective in family law and coming from the position of respect that I have for veterans, I do want to say that this bill at first blush may look like it is protecting vets and maybe merely codifying federal statutes. But I think that that's not really what's going on here, and that there are better ways to advance the cause of veterans in our country. What's happening with this bill is it is essentially hamstringing the courts and judges from looking at the specific factors under alimony analysis that are required in a divorce situation. There are a significant set of factors that allow the courts and the judges to kind of look at the entire big picture at what's going on. Military spouses give a lot for our country as well. So do the children. You move around. I consider myself an Army brat to a certain extent. And the families are also a part of this picture. And I would urge the Judiciary Committee here today to take a step back from a very specific and narrow view about the service-connected disability benefits and the arguments that it is to make that vet whole. Because what is really going on here is taking a step back and looking at what's best in the situation for the entire family. So when you hamstring the courts and you say to them the way that this bill might, you cannot in any way, shape, or form look at any service-connected disability benefits, period, then it potentially creates situations that are unjust or inequitable. So from that perspective, I think it's very important for everyone to just look at what's really going on. Let's give the family court the tools to make good, fair, honest decisions. And so I thank you for your time, and I will pass at this point for the others that are in opposition to AB 140.
Thank you. We got 7 minutes, so if you could, sir, go ahead and state your name for the record and proceed.
Thank you, Mr. Chairman. My name is Marshall Willick. I've practiced family law in Nevada for over 30 years. I was the managing editor and the primary author of the Nevada Family Law Practice Manual. And I wrote the textbook on the subject of military benefits about 17 years ago. I've studied the system and these benefits for decades. I teach the subject regularly, and I'm well versed in every aspect of each program in existence. Enacting AB 140 would be extremely poor public policy, would cause a great deal of harm to innocent parties, and it's based on some misrepresentations of what actually happens and why. 100% of the experts on the subject are in full agreement. There is no dichotomy of opinion from the people that actually know what this is and how it works. There is no significant adverse opinion. There is no example of a division of disability benefits as community property. It doesn't happen. Every court, from the United States Supreme Court in Rose on down, has held that essentially what Mr. Wheeler has said is simply not true. VA benefits are intended for both the member and his dependents. That is the holding of the United States Supreme Court and every court in the United States that's ever opined on the subject. They are collected in the materials that I have forwarded to each member of this committee if you want the actual legal analysis. This topic has to do not with the provision of disability benefits to members, but the conversion of retirement benefits into disability benefits, usually after the divorce has been granted. Upon divorce, the property between the two parties is allocated between the two parties. All other assets, houses, cars, the spouse's pension, such as Ms. Alton's retirement benefits as a police officer, those are all permanently divided. This bill would seek to take one particular kind of asset and allow it to be retroactively turned into something else, pulled out of the pocket of the person to whom it had been previously awarded, and by converting it in form, turning it into the property of the other person. That's the Section 2 that Mr. Wheeler was talking about. It would allow for conversion, and it's not to be permitted. The Brownell case, which is discussed in detail in Legal Note 53, which has been provided to you, is a wonderful example. There were $3,000 in disability benefits. There was $200 in food stamps. And the effect of this bill would say that the $3,000 per month is invisible to the court. The court can't look at it, can't think about it, can't know about it. The only thing that there is to divide would be the $200 in food stamps going to the spouse. So the spouse would get $100 worth of food stamps. The member would get the other $100 worth of food stamps and the full $3,000 in actual income. Disability income is income. All income is income. And divorce courts need to be able to see the entirety of the income of the parties in order to fairly allocate child support and spousal support, because all of these people need to live after divorce. There's a lot more analogies and arguments, but I think that that is the simple version. And with what time we have left, I'd like to defer to our third speaker.
Very good, sir. We got 3 minutes at this point for your testimony, so please come up and state your name for the record. A reminder, we will reopen.
My name
this
is
hearing
Roger.
later. I'm sorry, go ahead, Roger.
Okay. Thank you, Committee Chairman. My name is Roger Harada. I'm also a domestic relations attorney practicing in the state of Nevada up in Reno. And specifically, my objection about this bill is it is sort of something that the federal government has done that doesn't quite, in my opinion, make veterans whole for service-related disabilities, is then being taken advantage of by veterans in the recharacterization of their asset, which is their retirement asset. And later on after retirement, recharacterizing that or a portion thereof in disability for service-related injuries. And then there's an offsetting reduction in their retirement. So essentially for the veteran, they're at the same level, but they've recharacterized, and it's to their benefit to do so if it's available, to recharacterize a portion of their benefit to disability. What this bill then seeks to do is say, well, if this veteran has done that, then a court cannot consider that portion that has been recharacterized to disability. Now, the disenfranchisement of the spouses and the dependents, Mr. Willick has spoke to accurately. What the legislature should be careful about is this is just one more bill where we're saying, the legislature would be saying in passing it, we don't trust our judges to know what they're doing. So we're going to take away from the judges the ability to analyze the totality of the circumstances. And that, in my opinion, is one of the things that is really wrong when the legislature says, okay, we've heard from these public citizens, they don't like this, so we want to eliminate from the judiciary the ability to analyze this situation properly. We're going to eliminate, we basically have to have the judiciary thinking in a box here. And I think that is a bit of overreaching on the part of the legislature and an infringement of the separation of powers. We have an entirely different discussion there.
Mr. Harada?
The Veterans Administration, yes.
I'm going to have to stop and interrupt there. You the same Roger Harada that I went to high school with?
Yes, I am, sir.
How you doing? Nice to see you again.
All right.
Small world sometimes. I don't mean to interrupt.
You too, sir.
We will continue this conversation. I'm sorry. I am going to shut the hearing down right now on AB 140. I apologize. The interest in the other one is so enormous that I'm going to have to do that. But Roger, you and I will get together and discuss it, make sure everybody gets a fair shake on it. So thanks, everybody. Neely, I'm sorry. I thought you guys were there for 148. It's an error on my part. All right, we're going to close the hearing on 140 right now. Actually, recess it, I should say. We will come back and revisit that, especially for the opposition, to give them a little more time. Right now, we're going to open up the hearing on Assembly Bill 148. So I was actually given a list by the proponents of the people that would like to speak initially. We'll start with Assemblywoman Fiore, who will walk us through the bill. And then we have Professor John Lott and Sheriff Chuck Allen, who I'd like to have come up to the table first. Good morning, Miss Fiore. Got your name right today, huh?
You did. Thank you, Mr. Chair. My name is Michelle Fiore. My chair keeps wanting to call me Michelle Flower, which it's very similar because Fiore in Italian does mean flower. So, I am presenting to you today AB 148. And I'm going to take you through the bill. Sections 1 and 5 of this bill authorizes sheriffs and campus police within the limits of available money to provide concealed firearm permit holders with information regarding instructors and organizations that offer courses focused on firearm safety in educational environments. Section 2 of this bill is a numbering change to accommodate the new paragraph added in Section 3. Section 3 and 4 amend the NRS 202.265 and 202.3673 to authorize those who possess a concealed firearm permit to carry a concealed firearm on the property of the Nevada System of Higher Education, a private or public school, or a child care facility. The Section 3 and 4 are extremely important. We're going to hear from Amanda Collins here in a little while to tell her story. Also, I just want to point out, because this section is quite important, that our teacher from Sparks, who also was a concealed weapons permit, 45-year-old former Marine, was shot and killed last year at his school, and it just puts our teachers at risk. So not only are our teachers defenseless at work by not allowing them to bring their concealed firearms on campus, we have also left our teachers defenseless when they go to the gym at 5 a.m. before work, or when they stop for groceries late after work coming home. A former maintenance supervisor of the Clark County School District contacted me and supported this bill because his former employees are dispatched to maintenance calls at our schools in the middle of the night. They are often alone and have no means to provide for their own safety. There's a young woman right now that works night shift as a custodian at UNLV. She rides her bicycle to and from work at night. She has a valid concealed firearm permit and requested permission to store her firearm in her locker at work and was denied permission. She does not have the option to leave her firearm in a vehicle parked off campus. Our current law is putting this woman at risk every night as she travels to and from work on her bicycle. In addition, under Section 11, Article 1 of the Nevada Constitution, it is legal to openly carry a firearm in the non-secure areas of public airports. This section amends NRS to allow those with a valid concealed firearm permit to carry a concealed firearm in the same areas of public airports where it is already legal to openly carry. 40 states right now, I'm going to show you this, it's in your packet too. 40 states allow concealed firearm in non-secure areas. If you look at this map, Nevada is one of only 3 states where open carry is legal, but concealed carry is not. This change makes Nevada law consistent with the vast majority of airports around the country, and all firearms are still prohibited in secured areas and beyond TSA screening checkpoints. Currently, it is also legal to open carry firearms in portions of public buildings that are open to public access. Unless otherwise prohibited, Section 4 would make it legal for concealed firearm permit holders to carry a concealed firearm in those same public buildings. Law-abiding citizens with concealed carry permits would no longer be considered a criminal because their shirt or jacket accidentally covered their firearm while standing in line at the DMV. Areas that are not open to access by public may still prohibit concealed firearms. In all of 2013 and 14, only 2 people with a concealed firearm permit were granted permission to carry their firearm on campus. Section 6 instructs the Board of Regents that those with concealed firearm permits must not be required to first seek permission to carry a concealed firearm. The Board may still require permission for anyone who does not possess a concealed firearm permit. Section 7 directs the Board of Regents to prescribe new rules for granting of permission to carry or possess a weapon in accordance with Section 6 of this Act. And Section 8, if passed, this Act becomes effective on July 1st, 2015. I'm going to hand it over to Mr. Lott.
Thank you, Professor. Good morning.
Well, thank you very much for inviting me. I appreciate Chairman Hansen and Representative Fiora inviting me. My name is John Lott. I've been a professor most of my life, having had positions at the Wharton Business School, University of Chicago, Yale, Stanford, Rice. But right now I'm speaking to you as president of the Crime Prevention Research Center. There are 3 general issues that I'd like to briefly address. One is the general behavior of permit holders. 2 is concerns about risks that might arise from permit holders being present at mass public shootings. And 3 are the possible benefits from allowing people to go and carry in what had previously been gun-free zones.
Professor, let me interrupt you for 1 second. You are the author of this, correct?
Correct. More Guns, Less Crime, from the University of Chicago Press.
Very good. So you are actually from Illinois?
Well, I lived in Illinois when I was at the University of Chicago, but right now I'm from around the Philly area.
Very good. Sorry to interrupt.
No problem. Thank you.
Please continue.
Anyway, with regard to the behavior of permit holders, if you look at the data for 2014, you had a revocation rate for permit holders of a little bit over 1/10 of 1 percentage point. If you look at anything that's related to either felony convictions or anything that might be related to violence, it's in about a little bit in the thousandths of 1 percentage point. But it's not even clear from the data that I was able to get from the legislative analysts whether any of those cases involve firearms. So that may be even an overestimate of the risk for people who have firearms permits. The experience is similar in other states. If you look at the states that we have information on firearms violations that result in revocations, it's usually in the tens of thousands of 1 percentage point, or at most thousands of 1 percentage point. And most of those are for relatively trivial cases. We have a lot of experience with regard to the gun-free zones that are being talked about in this legislation. With regard to colleges, for example, 11 states mandate that if someone has a concealed handgun permit, that public universities and colleges be mandated to allow them to carry in at least some form on college campuses. There are another 21 states that leave it up to the individual university to decide. With regard to K through 12, according to the National Council for State Legislatures, over 20 states in some form allow permit holders to carry permanent concealed handguns on school property. And prior to the early 1990s, when the Federal Safe School Zone Act was passed, basically any of the states that allowed concealed carry on school property. We can look at a variety of behavior, but if you look at crimes, for example, by permit holders on any type of school property, I've not been able to find, nor anybody's been able to point to an example of a crime that's been committed in a place where they're allowed to carry by permit holders. And I've been able to find 3 accidents that have occurred over time in either university or K through 12 property. All 3 of those accidents were non-trivial. Were trivial in terms of any harm that was done. Just to give you an idea of how law-abiding permit holders are, we recently did an analysis that looked at crime rates by police officers and comparing them to permit holders. I have a handout that's included there. And what you find is the police officers are incredibly law-abiding. The rate at which they go and are convicted of any type of felony or misdemeanor is less than 1/30th the rate of the general population. But if you compare it to permit holders are very law-abiding compared to police officers. At most, their conviction rates are about 1/6 the rate of police officers. We can also look at the behavior of college-age permit holders. There's a lot of concern about that, a lot of hypothetical things that might go wrong rather than guessing about this. There's several states that I have data for. I have a report that I presented to you for Michigan and Texas where we had data broken down by year of age. And what you find is that permit holders who are of college age, either 18 to 22 in the case of Texas or 21 to 22 in the case of Michigan, are at least or much more law-abiding than the general population, in fact. So it's not just a question of how young people behave, but the question is how do permit holders behave. Now, with regard to the second general issue, concerns about the risks in places like mass public shootings, there are a lot of hypotheticals that are raised. Primarily, examples would be what happens if a permit holder accidentally shoots a bystander when they're trying to stop one of these mass public shootings. You can go through every single one of the cases where a permit holder has stopped a mass public shooting. There's not one single case where a permit holder has accidentally shot a bystander. So is this possible that something like that might occur? Yes. But at least it seems like you should be able to point to at least one incident where something like that has actually taken place. With regard to the concerns that police, when they arrive on the scene, might accidentally shoot a permit holder, is that a possibility? Sure. But when you, in fact, look at the actual behavior of police officers, you find there's not one single case where a permit holder has stopped one of these mass public shootings where police officers have gotten confused and accidentally shot the permit holder by mistake. There are other issues that I could possibly go through, but those are the 2 main ones that usually seem to be raised in these cases. The third general area is one of the benefits from allowing permit holders. Probably the most striking piece of evidence to me is that if you look since 1950, with just 2 exceptions, every single one of the mass public shootings where 4 or more people have been killed have taken place where general population is not allowed to carry handguns. It's just not in the United States. In Europe, all the mass public shootings have taken place where people aren't allowed to defend themselves in that way. And these cases are just not random. You know, in Nevada, if you have a concealed handgun permit, you're allowed to carry your permit concealed handgun virtually any place in the state. If these types of attacks were random, you'd think that 98 or 99% of the attacks would be taking place where permit concealed handguns are allowed, rather than in the tiny areas within the state, either here or in other states, where permanent concealed handguns are banned. The thing that's interesting for anybody who actually goes through and reads the documents in these mass public shootings is how these attackers consciously pick out those areas where they know victims aren't able to go and defend themselves. I'll just give you a couple cases from this past year, for example. You probably read or know about the Santa Barbara shooting last June, in which 6 people in total were killed. Well, if you actually read the 141-page manifesto from the killer in that case, after you get by him complaining about women not appreciating what a great guy he is about 50 times, what you find is that he goes through excruciating detail explaining why he picked the particular venue to go and engage in his attack. There are multiple cases like this. I'll just give you one example. He mentions in the manifesto how the ideal target he would think would be spring break in Santa Barbara, which is where he was. Apparently, spring break is, and Santa Barbara is the mecca for students from around California, indeed much of the West, to go there to celebrate spring break. And he said that there would be a target-rich, to use his term, target-rich environment for him in terms of trying to kill the college-age students that he wanted to kill. But he did extensive research, as they frequently do in these cases, and what he said was, for example, he looked at old YouTube videos or read news reports, and he said there were just too many armed police officers in the area, and that maybe he could go and kill one or two of the police officers, but since there were so many police officers there who would be armed, he was sure he would be killed before he could go and start killing the students, which were his primary target. And so he then went on to other targets that possible targets that he discussed. Just a couple weeks after that, in Moncton, New Brunswick, Canada, there was another mass public shooting. On the killer's Facebook page, he had literally a dozen comics about gun-free zones and making fun about gun-free zones. On one of the comics that he had a mass public shooter. He had a victim who was trying to stumble and run away from the mass public shooter, and the victim was turning to the killer saying, "You can't have a gun here. We banned guns in these places. You can't shoot me." And above the killer's head, he has a little bubble saying, "What a moron," as he's aiming the gun at the person who's trying to run away. All I'm trying to make clear here is that this person was obviously aware of gun-free zones and was considering them in, or would have thought about them in connection with his attack. Those are just from this last year. There are many other similar cases over time that one could go and point to. You look at something like the Batman movie theater shooting. There were 7 movie theaters within a 20-minute drive of the killer's apartment. Only one of the movie theaters actually posted signs banning permanent concealed handguns. The killer didn't go to the movie theater that was closest to his home. He didn't go to the movie theater that posted that it had the largest auditoriums in the state of Colorado, which you would think would be attractive for somebody who wanted to kill as many people as possible on a premiere of a Batman movie. Instead, he went to the only movie theater that posted signs banning permanently concealed handguns. You can go to our website. We have a long list of mall shootings, and what you find is that in every single one of the mass public shootings involving malls, they all were posted areas where people weren't allowed to go and carry permanently concealed handguns. Even though there would be many other malls in the area, often closer to the killer's home, that were not posted, they would continually pick the areas that were posted. Now, I'll just leave you with one general thought. Ron Noble, who's the head of Interpol, kind of Europe's version of the FBI, a little bit broader than that, after the Westland Mall killing in Nairobi, Kenya in 2013, came out with a statement. He basically said there were like 68 people that were killed in that mall shooting, 157 people who were wounded. The reason why I bring this up in part is just 2 weeks ago, the Somali terrorist group who was involved in that Kenya shooting made a threat against Mall of America, which actually also happens to be a gun-free zone, the largest mall in the United States, Minnesota. But if you look at Ron Noble's statement, he basically said there's 2 ways to stop these types of attacks. You can either make an area a gun-free zone, or you can allow victims to be able to go and defend themselves. And he said his views have changed dramatically over time. When he first became head of Interpol, he thought the obvious solution was just to ban guns from certain areas. But what he had learned over time is that it's basically impossible to actually effectively ban guns from areas, that particularly when you're dealing with terrorist groups or other people who are planning these attacks. And these mass public shooters that we have in the United States, you take something like Adam Lanza. He's planning it for 2.5 years. Other criminals, a year. Short periods of time, there are 6 months that they're planning these attacks. But when they're planning these attacks for long periods of times in advance, he said it's basically impossible to prevent them from bringing weapons into the area. And so what he said was, the only people you're really disarming are the victims in this case, and not the people who are perpetrating the attacks. And so he said himself and others who he's talked to have changed their opinion about what might be the best way of going and trying to stop these attacks. What might seem the most obvious way of solving it to begin with actually makes it safer for the criminals to go and do the attack and make it more likely they'll be successful. In my work with Bill Landis at the University of Chicago, when we did research on this, we basically found that the one thing that determines how many people get killed or injured in these attacks is the amount of time that elapses between the attack starts and when someone is able to arrive on the scene with a gun to stop it. And I thank you very much for your time.
Professor, thank you. Sheriff Allen?
Good morning, Chairman. Ladies and gentlemen, Sheriff Allen, Sheriff of Washoe County. I'm here to show my support of Assembly Bill 148. As you know, being the 26th elected sheriff of Washoe County, fairly new to the organization, the majority of voters who voted last year voted for my platform. My platform is a very pro-Second Amendment platform. I had the opportunity to address campus carry in many public venues, and my position on that bill has not changed today. I do believe that those citizens who are, by the way, checked with a background check, who obtain a CCW, should have the right to carry a firearm. I also had the opportunity to sit down with Amanda and her father, Tom, about this time last year where she shared her story about the atrocious act that happened to her on the university campus. I do believe that folks know the rules when they are given the opportunity and right to carry their firearm concealed, and that is the key right there, keeping the firearm concealed. Part of the training does include holstering, deploying, firing the weapon, qualifying with the weapon, etc. I won't belabor you with that, but primarily I'm here to show my support for the bill. I won't be able to stay here all day, and I wanted to point out that my representative assigned down here full-time, Lieutenant Eric Spratley, will be here as well. Thank you.
Very good. Thank you, Sheriff. Yeah, Lieutenant Spratley does a great job for you. Are there any questions at this time for these three? Mr. Araujo and then Mr. Anderson.
Thank you so much, Mr. Chair. Thank you all for being here today. Ms. Fiore, this question's for you. According to numerous surveys, there is widespread opposition to forcing colleges to allow guns on campus. Let me give you some statistics that I was able to pull up. 95% of college presidents oppose guns on campus. 94% of faculty oppose guns on campus. 79% of students said that they would not feel safe if faculty, students, or visitors were allowed to bring concealed guns onto their campuses. Recently, the student body of UNR, the student governments, in a resolution voted to oppose AB 148. Furthermore, the president of UNR in the paper yesterday made a comment, and it states the following: "They are not doing this for us. They are doing it to us." So given this broad opposition from the folks who would be directly impacted by this legislation, why are we forcing them to abide by AB 148?
She's asked that I respond to this. I mean, I've been an academic most of my life.
Professor, state your name again.
Oh, excuse me, John Lott. I've been an academic most of my adult life. I've been around academics and students. It's not something that I take particularly lightly. I'm not sure about the exact polls or who conducted them or what was done there. But look, this is a safety issue that's here. You can look at polls of police officers, for example, people who have expertise in safety issue, unlike the people who are being polled in the polls that you're referencing. Police One is the largest private organization of police officers in the United States with about 450,000 members. 370,000 are active duty. You have another 80,000 of them are retired police officers. And yet, and there are about 600 and some thousand police officers nationwide, just to give you an idea how much of the police officers they represent for full-time officers. 80% of their members believe that allowing people to carry permanent concealed handguns in previously gun-free zones would reduce the amount of carnage. When their members were asked what's the single most important thing that could be done to stop mass public shootings, the number one response that they gave was to eliminate gun-free zones. So, I mean, one can go and look at polls. Look, if you look at people's perceptions, how they change on concealed carry before and after states have adopted concealed carry, there are a number of states where concealed carry was passed where polls indicated that people opposed concealed carry. But after a year or two, I'm sure you've seen the polls on that, what's happened? People have realized that a lot of the fears that they had simply haven't come to pass, and support for concealed carry generally in those areas has increased dramatically. My guess is, look, I understand what people's reaction is. They think by simply banning guns from an area, that will make it safer. The problem is you have to ask who obeys the law. And while we'd like to believe, like Ron Noble originally thought, that if we ban guns from an area, that's going to make it safer, unfortunately, the people that obeyed that are the good, law-abiding people, not the people who are intent to doing the attack. If the Somali terrorists go to the mall, at the Mall of America, and they see a sign saying that guns aren't allowed in the mall, do we believe that they're going to honor the sign that's there and not take the guns into the mall?
Thank you. Mr. Anderson?
Thank you, Mr. Chairman, and good morning, Ms. Fiore, Professor, Sheriff. I wanted to talk a little bit about the learning environment. That's something that's pretty important to me. I'm a UNLV law student, and so I know when I go to school that I want to be focused. Now, as it turns out, I'm a little bit more comfortable with weapons personally. I've been around them, grew up with them, Marine Corps, etc. But I know that not every student that's going to be in a class with me is as familiar as the sheriff might be, or I might be, or you might be, Ms. Fiore. So what I'm asking is that, what would be your answer to them when you say that you're bringing this element into their learning environment? They're there to focus. They're paying a lot of money for school. They're not as comfortable with it as we are. What would you say to them when we're putting it into their environment?
Thank you, Mr. Anderson, for the question. I wouldn't say anything to them because
State your name.
Thank you. Sorry, Chair. This is Assemblywoman Michelle Fiore. Mr. Anderson, I wouldn't say anything to them because they will not know that I am the one standing next to them with my firearm on my person. So there's no reason to fear. When I'm walking through the building, you don't see my firearms open. You don't see where I conceal my firearm. So I think that the non-threat that you guys are trying to visually paint out there is a non-issue.
Mr. Orenshaw?
Thank you, Mr. Chairman. Good morning, Assemblywoman. Good morning, Professor. Good morning, Sheriff. My question for whoever would like to take it. According to the National Institute of Alcohol Abuse and Alcoholism, 4 out of 5 of college students in our country consume alcohol. According to them, half of those college students who do drink also do binge drinking, and they've got data showing that last year over 600,000 of those students hurt themselves during binge drinking. University of Michigan has a study that states that in 2013, 34% of college students across the country used some kind of illicit narcotics. My concern is if we add firearms to the mix of our college campuses where we've got young people who are trying to decide what they want to do with their lives and are also experimenting with substances like this, doesn't that create a dangerous recipe? And anybody who'd like to answer it?
This is John Lott responding to the question. Look, that's the reason why I looked at the experience in other states that are there. You have 11 other states that mandate that once somebody has a concealed handgun permit, they're allowed to go and carry it in some form on university campuses. You have another 21 states that leave it up to the individual university to decide, though most don't allow it in those 21 states. The types of concerns you're raising, sure, there's hypothetical things, but can you point to cases in any of those states? Some of those states have had it for long periods of time, a decade and a half or so, in parts of Colorado or Utah or other places. Any examples of the types of concerns that you're raising have occurred? It's not just that there's some young people who are irresponsible. There's some old people who are irresponsible. The issue is permit holders, the type of person who's willing to go through the process to go and get a concealed handgun permit, do they represent a risk? And if you look at the handout that I gave you from a report that we did last year looking at states where we could break it down by even year of age, young college-age permit holders are at least as safe or safer than the rest of the permit holders, and permit holders as a whole are extremely law-abiding. And you can't find a single example of the types of concerns that you raise in any of those states having occurred. Not one example. You know, if you could go and point to maybe 2 or 3 or 4 or 5 examples, given how many states and how many schools we're talking about, then it seems like it would be an issue to go and debate. But since you can't go and point to a single example of something like that happens, it seems like it's not, while it's hypothetical, it doesn't seem particularly relevant for analyzing the particular bill that you're looking at right now.
Mr. Thompson?
Thank you, Mr. Chair. This question is for Professor Lawton. So I know you've done very extensive work in like Michigan, Texas. You've given us some handouts, Chicago, and so forth. I was just wondering, since we're talking specifically about Nevada, do you have any data, statistics, done any analysis of our state? And not just on the higher education level, but because this bill, from my understanding, is also going to deal with private and public schools, and it's also going to deal with child care facilities.
John Lott again. Thank you very much for your question, sir. No, I mean, all my work that I've done, my book, Morgan's Less Crime, that the chairman pointed to, looked at data for all the states, looked at revocation rates for all the states, including Nevada. Nevada is pretty typical. I've recently, over the last week, looked at revocation rates for college-age students in Nevada, and they're no different than the revocation rates for the general population in Nevada. And so, you know, some of the things you could only look at maybe after you change the law, you know, what would they be like on college campuses? But you can go and see those permit holders, presumably when they're across the street from the college campus and they're carrying, or other places in the state, and they seem to behave just as responsibly, just as low of a revocation rate as the rest of the population that carries concealed handgun permits. So unless you're concerned about concealed handgun permit holders generally in the state, it doesn't seem like there's any evidence that college-age ones would be of greater risk that's there.
Mr. Nelson?
Thank you, Mr. Chair. Following up on Mr. Orenfeld's comment about alcohol and guns mixing, isn't it true that the campuses, which would include the fraternity houses and the sorority houses, are supposed to be dry with no alcohol?
Yes. So are you saying these non-concealed weapons permit, the non-gun people are breaking the law? I mean, are they not abiding? They are supposed to be dry campuses. There's no alcohol allowed on those campuses. Thank you for the question.
Ms. Diaz?
Thank you, Mr. Chair. Assemblywoman Fiore, I have specific concerns, especially about now them being able to carry in our airports. I think it's a little overreaching, especially when the driver of our Nevada economy is tourism, and we have a lot of international tourists that come to our city, and they are not accustomed to environments in which citizens can carry guns. So these are 41 million people coming to visit, and it is the biggest influx to our revenue. So you're telling me that it's more important that we pass your bill and allow people to carry at airports and all and everything, and not really think about what will it do to our revenue, our tourism, and then that is going to obviously strain all of the public services we have to provide for our Nevadans.
Thank you for the question, Assemblywoman Diaz. So I think that the question that you posed, I don't think that you're aware that I can walk into our airports right now, today, with my gun on my hip openly. So I prefer to conceal my weapon. So, people, it's not visual. But right now, it is the law here in the state of Nevada. I can drive into the airport. I could walk into the airport. I can walk all around the airport. I just can't pass the TSA. And I could have my firearm on my hip openly. So today, we are allowed to have guns at the airport.
Ms. Seaman?
Thank you, Mr. Chair. And I think you've answered part of my question, because I was going to ask you, has our open carry law deterred any tourists that you know of?
Thank you, Assemblywoman Seaman, for that question. No, it hasn't. So our tourists are still coming to Nevada. And, you know, I think it's really telling in this last election cycle with all the anti-gun nuts out there spending millions of dollars out of New York City. I think Nevada made a loud and clear statement to don't touch our guns.
Okay, seeing no further questions for these three, thank you very much for your testimony at this time. I'd like to call up, actually we're going to go to Amanda Collins, and I'd like to have Lisa Thomas, Alicia Ketter, and Sarah Ketter come up to the witness table at this time. Amanda Collins, can you hear us okay? Got a little bit of a little time delay, but go ahead, I'm sorry.
That's okay, I had to unmute the microphone. Mr. Chairman of the Judiciary Committee, I want to thank you and the members of your committee for giving me time to talk with you this morning via video conference. And I will keep my comments brief, as I'm well aware that some of you, for some of you, this is your third time hearing me give testimony before to this particular committee on this piece of legislation.
Amanda, go ahead and state your name for the record.
Oh, I'm sorry. I'm Amanda Collins, and I am representing myself as a private citizen. So just the other day, actually, I was asked, why do you need a firearm on your college campus? What's so threatening about being educated? And here's my answer. It's the same question that I've asked for years, and I have yet to receive a response. How does rendering me defenseless protect you against a violent crime? When I was 22 years old, I lived through my worst fear. And what has become a story that most people appreciate hearing is my reality. October 22nd, 2007 was a typical Monday evening. The only thing that seemed to be different was the midterm awaiting me at my class at the university campus. At 10 p.m., I walked to the parking garage with a group of colleagues in an attempt to ensure my safety. I parked in this particular parking garage because it was very close to where my class was being held, and it was seemingly safer, or presumably safer, to park there than it was to park off campus and have to walk across campus at night by myself. As I approached the parking garage, I was the only one who had parked on the ground floor. And seeing no visible threat between myself and my vehicle, I wished everyone a good week and broke off from the group. Approaching my vehicle at an angle, what I didn't see was a man hunched down by the wheel well of a truck next to a sedan. As he passed me, he grabbed me, forced me to the cold, hard asphalt, placed a pistol to my temple, clicked off the safety, told me not to say anything. And then he began to brutally rape me. As I lay there defenseless, straddled by a man much larger than me, out of the corner of my eye, I could see the university police cruisers parked across the way. And in that same moment, I knew that the university police offices had already closed. So while my body was being ripped apart, I knew no one was coming to help me. Eventually, the man who raped me, James Bila, was caught. He was tried and convicted for not only raping me at gunpoint in a gun-free zone, but also raping 2 other women and murdering Breonna Dennison. At the time of my attack, I had obtained my CCW permit for the personal choice of not wanting to be a defenseless target. However, in Nevada, permit holders are not allowed to carry firearms on campus. And as a law-abiding citizen, I left my firearm at home, which means that the law, the very law that was meant to ensure my safety, only guaranteed the criminal an unmatched victim. I still wonder what would have been different if I had been carrying my weapon at night. But had I been carrying my firearm, I would have been able to stop my attack. Not only that, 2 other rapes would have been prevented, and 3 young lives would have been saved, including my own. Any survivor of rape can understand that the young woman walking into the parking garage that night was not the same woman leaving. My life has never been the same after my attack. And legalized campus carry would have saved my family, who happens to be the collateral damage in my story, and me a great deal of untold torment. My case is a perfect example that despite law enforcement's best efforts to ensure our safety, they are unable to be everywhere at once. All I wanted was a chance to effectively defend myself. The choice to participate in one's self-defense should be left to the individual. That choice should not be mandated by the government. And as a law-abiding citizen, I should not have to hand over my safety to a third party. Laws that prohibit campus carry turn women like me into victims by stripping away our Second Amendment rights. Unfortunately, legislators and university officials opposed to campus carry are seemingly more intimidated by law-abiding citizens like me, sitting in class with my legal permitted firearm, than they are of the rapist waiting for me in the parking garage. I have heard all the what-if questions that have actually never happened in the 11 states that currently allow campus carry. Not a single one of those states has seen an increase in crimes committed with firearms. In fact, there has been a decrease in crimes committed on campus property. I know from my personal experience that threats to personal safety don't magically disappear in declared safe zones. Recently, I have also heard the argument against campus carry, stating that it will arm the assailants too. That statement ignores the fact that assailants are already armed, and there is nothing in place to keep them from coming onto our campuses. My attacker was armed, and as a law-abiding citizen, I had more to lose that night if I had carried my weapon than he did. If I had had my weapon, as the current law stands, I would have faced expulsion, loss of my permit, and possibly jail time. My attacker was not a student, nor did he have a CCW permit. I am often told that my case is just so rare. In fact, just yesterday, the Reno Gazette-Journal quoted the Speaker of the Student Body Senate at UNIDAR, Caden Fobby, saying, "There's this misconception that there's a guy jumping out of the bush," and that's just not the case. Most people are unaware that 1 in 4 women will be raped while they attend college, and a third of those attacks will occur on the campus they attend. A study from the Journal of Interpersonal Violence found that 126 admitted perpetrators had committed 907 sexual assaults involving 882 victims. I want to repeat that. 126 admitted perpetrators committed 907 sexual assaults involving 882 different victims. That's an average of 7 victims, some more than once, per perpetrator who is currently serving for 1 sexual assault. And with this information, I can confidently say that what's rare about my case is that I'm talking about it. Just because it's not making media headlines or being reported at all doesn't mean it's not occurring. The majority of rapes go unreported, as did mine initially. What if a woman gets raped is the main argument I hear in support of Roe v. Wade. However, if we as a society cared about women getting raped and really wanted the government to stay outside of women's bodies, then we would do whatever we could to equip women with the ability to prevent rape. I believe in empowering women with the choice to protect their bodies. Therefore, law-abiding concealed carry permit holders should not be denied their fundamental constitutional right to protect themselves on college campuses in the same manner that they're able to protect themselves everywhere else as they go about their daily lives. And with that, I just want to leave you with the same question that I've been asking for the last 5 years, and I have yet to receive an answer. How does rendering me defenseless protect you against a violent crime.
Thank you very much, Amanda. Are there any questions for Amanda at this time? Seeing none, thank you very much. We are going to go back up here now. We'll go to Lisa Thomas at this time.
Good morning, Mr. Chairman, members of the committee. My name is Lisa Thomas. I am a tenured associate professor at the University of Nevada, Reno. Before I begin my remarks, I need to be very, very clear that my testimony delivered today is delivered on behalf of myself as a private citizen. I'm not authorized to speak on behalf of the University of Nevada, and my remarks aren't intended to reflect the position of the University of Nevada, Reno. I'm pleased to be here today in support of Assembly Bill 148, a bill that would allow concealed weapon permittees to lawfully carry a concealed weapon on the properties of the Nevada system of higher education. To be clear, this bill is not about allowing violent criminals to brandish firearms in the classroom. This bill is also not about allowing private citizens without training to have weapons on campus. Rather, this bill intends to allow Nevada residents who are over the age of 21, who have received documented training, who do not have a violent or drug-related criminal history, who have not been judicially declared incompetent or mentally ill, and do not habitually use alcohol or controlled substances to exercise their right to carry the concealed weapon that they carry every day. You may be pleased to know that I'm not here to talk to you about the Second Amendment. I'm confident that you're going to hear plenty about the Second Amendment from witnesses that follow me. But rather, I'm here mostly to talk to you about my personal experience. In February of 2014, I had the unpleasant task of informing a student in our nursing program that he would no longer be permitted to participate in classes. The student became extremely, and to me, terrifyingly angry, stepped into my personal space, and, paraphrasing his language, informed me that I better watch my effing back and that I would regret this action. The student then proceeded through the department where he continued to terrify faculty and staff. A 911 call was made. The university police, accompanied by a canine unit, responded within 5 minutes of that initial 911 call. And I really want to give credit to the university police department. Their response was prompt, it was efficient, it was exceedingly professional. However, the reality is that we were alone and defenseless with an incredibly agitated and very scary individual until they arrived. Immediately after this incident, I applied for and received a court-issued order of protection from the Reno Justice Court. This order of protection has been extended a total of 5 times as a result of this student's continued threatening behavior. During these court hearings, the judge asked, "What is the university doing about this?" The only answer I could provide at the time was, to my knowledge, the university is not taking action on this matter. During this time, a single piece of paper issued by the court informed the student that he could not enter the building in which my office is located and the building in which I teach. My actions and my responsibilities on the university campus, however, take me to all parts of the campus. A full 10 months later, the student was finally banned from the university campus. But this ban was not related to the student's interaction with me directly. Rather, during a student-initiated meeting with campus administrators, the student spoke of school shootings and made reference to community shootings at the Nevada Urology Clinic, where Dr. Garo Godoyan was killed and Dr. Christine Lajeunesse sustained wounds that ended her surgical career. I wasn't there at that meeting, but I understand the gist of the conversation to be along the lines of bad things happen when people are pushed too far. So I mentioned earlier that the university police responded within 5 minutes of the 911 call that originated from the Health Sciences Building. While this is an absolutely commendable response, I'd like to provide some perspective on just how much devastation can take place in the moments between a 911 call and the arrival of law enforcement. The best example was referenced earlier by Mr. Lott and can be found in the tragic case of Adam Lanza, the perpetrator of the Sandy Hook Elementary School shooting. When Mr. Lanza shot his way through the front window of Sandy Hook Elementary School, the first 911 call was placed at 9:35 a.m. The first officer arrived on the scene within 4 minutes of that first 911 call. In that amount of time, 20 first graders, 6 faculty members, and the shooter were dead. Much, I am sure, to their devastation, the role of the Newtown, Connecticut Police Department was to take reports, collect evidence, identify the deceased, and reunite the surviving children with their parents. Sung Hui Chao entered Norris Hall, which housed the Engineering, Science, and Mechanics program at Virginia Polytechnic Institute at 9:40 a.m. on April 16, 2007. Police arrived to the scene within 3 minutes of this first 911 call. By the time police reached the interior of the building, 27 students, 5 faculty members, and the shooter were dead. Again, police had the unenviable job of identifying the deceased, collecting evidence, completing reports, and making death notifications. A final example is closer to home for nursing faculty such as myself, because the situation is very similar to the situation I experienced. Robert Flores Jr. failed a nursing course at the University of Arizona Nursing School. Mr. Flores entered the School of Nursing and specifically targeted individual faculty he believed were responsible for his failure. Police responded to this scene within seconds. Again, in this case, by the time police arrived, 3 faculty members and the shooter were deceased. Even closer to this home in this very community, and you heard this morning from Ms. Amanda Collins, James Vila assaulted a number of women around the University Nevada campus and brutally raped Ms. Collins before finally abducting and murdering college sophomore Brianna Dennison. As a law-abiding citizen, Ms. Collins had complied with the prohibition of weapons on the university campus. The attacker, however, did not. I do wonder every day if Ms. Collins had been permitted to carry her lawfully owned and permitted concealed weapon on her person as she walked to her vehicle that evening, if Ms. Dennison would still be alive. There are many other similar reports of violence on the U.S. campuses in this country. There's one commonality between all of the perpetrators and all of the situations. The commonality in the situation is that the police were minutes away when seconds mattered. Though Adam Lanza, Sung Hui Chao, Robert Flores, and James Vila were different people with different backgrounds and different challenges, they also share a commonality. Not one of those perpetrators were lawfully permitted to carry a concealed weapon. Yet they did so without regard to rules prohibiting weapons on the campuses on which their crimes occurred. Each of these acts of violence occurred in gun-free zones, which meant that only the people who chose to violate these laws were armed. This also meant that these perpetrators could proceed with their crime with a reasonable degree of certainty that they alone would be the person in the situation with a weapon. Had another person been legally armed in these situations, the legacy left by these tragedies may well be considerably less devastating.
Professor, I'm going to have to ask you to wrap it up. I've got 6 more people before I go to the opponents, and I'm running out of time for everybody. So if you would summarize a little bit here real quickly.
I will move forward. The day after this event took place with this student that I worked with, I I wrote to the university president asking the president for permission to carry a concealed weapon on campus. His response outlined the fact that students under the age of 18, preschool students, elementary school, spent time on the campus. I would submit to the committee's consideration that those same children spend time in parks, restaurants, and right across the street from campus. What is it that makes them at risk when they cross an arbitrary boundary onto the university campus? And what makes that weapon carrier suddenly a risk to them? So as I close my remarks, I just want to be absolutely clear that my personal philosophy with regard to defense mirrors that of most lawful concealed weapon carriers. The shared philosophy is to retreat until the option no longer exists. Being forced to use my firearm in a self-defense situation would be the worst day of my life. But I would be here.
Thank you very much, Professor. Let's go to Elisa Ketter now. Elisa, good morning.
Good morning, Mr. Chair. Members of the committee, thank you for having us. I'd like to offer a slightly different perspective. My name is Alicia Ketter, and I'm a resident of Reno, Nevada. I'm a professional software architect for a Fortune 500 company. I am a wife and a mother of two. My daughter sits next to me, and she'll be speaking next. I'm also a firearms instructor here with the Women's Shooting Academy. I currently hold 5 NRA instructor ratings, and I'm certified to instruct students and certify them to receive their CCW permits in 4 states. I fully support this bill, as it would remedy a number of challenges that I face every single day. I'm accompanied here by my husband and my two children, who are also impacted by this proposal. In the fall, my son will be attending the University of Nevada, Reno, and under the current law, I would be forced to park off campus in an arguably dangerous neighborhood and walk unarmed to any campus event or even to visit my son. While on campus, I am offered only a blue call box and the hope of a nearby campus police officer to assist me if I need it. I am not satisfied with that option. Likewise, my daughter attends a local elementary school where there is no off-campus parking available to me to park my car and disarm and then go on campus. So I must drive a long distance to and from her school unarmed through both rural and urban areas. I have yet to see an armed school police officer on her campus. Both situations have effectively denied me the right to protect myself and my family. They have also endangered the lives of my children, since according to the Crime Prevention Research Center, 92% of mass shootings occur in these gun-free zones. In the event of a shooting, my children and their teachers will be defenseless, left to huddle in a dark room and pretend that they aren't there. The CPRC showed that only 8% of mass public shootings occurred in places where citizens have guns for self-defense. Even attending this meeting today has rendered me unarmed, as the current legislation grants the director of the Legislative Council Bureau the sole authority to deny me the right to carry my firearm in this building. I petitioned the current director for permission to carry my firearm here, and I was repeatedly denied. The director, in turn, recommended that I leave my firearm in my car and tried to comfort me by saying that the legislative police make their rounds regularly. I would like to remind you that this solution was not very reassuring to the staff here when an incident with Assemblyman Stephen Brooks occurred last year. He made threats against other members of this very body. He was ultimately arrested and convicted of felony gun charges. I know of at least 4 staff members in this building who obtained their CCW permits in order to protect themselves as a direct result of Mr. Brooks' threats. This clearly illustrates the fact that threats can come from the most unlikely of places. Opponents of this bill would have us rely on law enforcement officers' response in an emergency. But as you may know, the Supreme Court ruled in Warren versus the District of Columbia that officers have no duty to protect individuals. In fact, they do not have a duty to provide any police services or even respond to a 911 call. I asked this committee and the bill opponents why they would force me to surrender my responsibility for my safety to a police officer who has no duty to protect me. Please tell me how disarming me protects you, my children, or the public. I stand here today completely unarmed and at the mercy of anyone who defies the paper signs at the entrance of this building and means us harm. I am forced to relinquish my right to choose my method of protection. I implore you, do not be swayed by the emotional rhetoric that has been paid for by New York billionaire Michael Bloomberg. What could he possibly know about how us Nevadans live? Do not be fooled by the racially charged and factually inaccurate claims we have heard in several of these committees, paid for by Mr. Bloomberg via Every Town. Nevada is not every town. Nevada is battle-born. Nevada means home. Please right this wrong and do not continue to disarm and endanger the citizens of Nevada. I urge you to pass this bill. After all, even California has an exemption for CCW carriers to carry on campus. We can't be outdone by them.
Thank you. Thank you very much, Ms. Ketter. Ms. Ketter, Sarah, would you like to testify at this time?
I am Sarah Ketter. I live in Reno, Nevada. I am an elementary school student. Both my parents are CCW permit holders. I want to know my mom is able to protect me in troubling situations, anywhere, anytime. If that takes place at a school, I want to know she won't be faced with charges for pulling her gun to protect me. My mom is my first responder. When I walk out of school, I want to know I'm protected, that I can walk to my car knowing no one is going to kidnap me, that my parents and teachers can protect me if anything happens. This bill will give me that security. When the time comes that I go to college, I want to know that if I choose to protect myself, I won't be considered a criminal for doing so. When I'm of age and I have my CCW, I should be able to walk with a gun on my side and feel secure. It reassures me to know my parents are skilled to protect me. It gives me comfort to have my family at home and know that I'm safe. To have my dad see me when I come home and know I'm safe without a scratch. To know as soon as I leave home, I can protect myself, whether that be when I'm a college student with a CCW and carry on my own, or when I am with my mom and she can protect me. This bill could save my life someday. Please consider that as you make your decision. Thank you.
Thank you, Sarah. Now, what I'm going to do, I'm going to allow the proponents to continue until 10 to 10, and then I will allow I have 9 people that will testify in opposition. Don't run off yet, which will take us to 5 after 11 if they use it all up. I'm trying to get everybody in on both sides equal time. So I have 3 more people, and I've got about a little less than 15 minutes. Are there any questions right now for these 3? Seeing none, why don't we bring up Vicki Kowalmacher, Carol Morrell, and Tom Collins. And these 3 will wind up our testimony for the proponents, and then we'll move to the opponents. Good morning, Vicki. Nice to see you again. Welcome to the Committee on Judiciary.
Good morning, Mr. Chairman and members, ladies and gentlemen of the Assembly. My name is Vicki Kowalmacher. I am a legal, law-abiding American citizen. I am a wife, I am a mother, I am a sister, daughter, grandmother, friend. I am also a women's safety advocate and speaker. And for the record, I am a firearms instructor for my company, the Women's Shooting Academy, here in Reno, Nevada. I fully support Assembly Bill 148, and I would like to personally thank Michelle Fiore for spearheading this effort once again. I urge the committee to pass this bill. 7.5 years ago, I received the biggest wake-up call of my life. 2 men sitting in a parked car on my street attempted to abduct my then 10-year-old daughter. We immediately called 911, and guess what? They did not come. I was told that I could go to the sheriff's substation the next morning and file a report. Wow. That was not very comforting to know that help was not coming, but a reality that I had to embrace. The next morning, I walked into a local gun shop and I purchased my first official carry gun. I made a decision that day, and it's a decision that I will carry with me for the rest of my life. I am worth protecting. I am it. I am the first responder for my family. I ask each and every one of you right now, who in your life is worth protecting? Is it one of your children? Is it your spouse? Maybe it is your parent, or perhaps your best friend. Regardless of who it is, I know that each one of you thought of someone. I tell you that story to help you understand my frustration. I have great respect for law enforcement, but due to budget cuts, they cannot be everywhere protecting everyone. My daughter Johanna is now a young woman, a senior in high school, and she will be attending a college in Reno in the fall. I find it appalling that when I am on her campus, I am completely stripped of my right to carry my firearm. Gun-free zones do not stop heinous people from doing the unthinkable. Amanda Collins is my friend, and I love her like a daughter. Where was help on October 22nd, 2007, in that parking garage of UNR? A gun-free zone. No one can say with certainty that had Amanda been allowed to have her firearm that fateful evening, she would have been able to defend herself or prevent her rape. But maybe, just maybe, she would have. The man who brutally raped her was armed with a firearm, and as we've heard, this man went on to kill his next victim. Assembly Bill 148 is not about rape. It is about having the right to carry a firearm if you meet the requirements and you choose to do so. It is a very personal choice, and I believe everyone has the right to that choice. I have personally trained teachers and professors who currently teach and are willing to risk their job because they know that their life is far more valuable than some policy. A policy that won't be there when it's going down and the armed gunman is choosing their next victim. I have sat with, I have cried with, and I have held women who have been victims of many different types of crime, rape, domestic violence, stalking, and the list goes on. I sit here now as their voice because they are unable to be here. I have also submitted statements for the record on their behalf. If you're going to limit our ability to protect and defend ourselves and those we cherish in public places, then I ask each and every one of you now as I look you in the eye, what is your solution? In fact, let me ask you the same question that Amanda asked you. How does rendering me defenseless protect you or anyone else against a violent crime? I ask you to consider the answer to that question when you cast your vote. And for the record, if I had my firearm on me today, I would choose to protect each and every one of you should the need arise. Please pass this bill. Vicki Callmaker.
Thank you very much, Ms. Colmaker. Patty McConnell, would you like to go ahead and testify at this time?
Well, this is Carol Morrell.
Oh, I apologize. Carol Morrell, please go ahead.
Thank you. My name is Carol Morrell, and I thank all of you here and Michelle Fiore as well for this opportunity. My husband and I moved here to Story County in 2001 from Southern California. The reason we moved to Nevada is because Nevada gives us a lifestyle that we greatly appreciate. Very few restrictions on our personal freedom, and hugely support the Second Amendment and our Second Amendment rights. I've been living with firearms and shooting firearms for about 30 years. I've been an NRA member since 1985. I'm a firearm instructor. I have taught women and men safe gun handling skills for about 6 years now. I hunt, and I've been a competitive shooter for about 12 years total. I'm also a parent. I'm also a grandmother. I have something to read from Wikipedia, just real quick. The Bill of Rights is a collective name for the first 10 amendments to the United States Constitution, proposed to assuage the fears of anti-federalists who had opposed constitutional ratification. These amendments guarantee a number of personal freedoms, limit the government's power in judicial and other proceedings, and reserve some powers to the states and to the public. Originally, the amendments applied only to the federal government. However, most were subsequently applied to the government of each state by way of the 14th Amendment through a process known as incorporation. So basically, the Second Amendment is more than just a rule. It relates to the basic human right for self-defense. Nevada law is generally very reasonable when it comes to concealed carry laws. However, if an individual is 21 years of age, does not have a background of aggressive or violent behavior, and has successfully passed the criteria and training needed to obtain a concealed carry permit, how is it that that same individual will suddenly become reckless and hostile and use their firearm to harm or kill someone in a specific location of our community, but not in another? By moral conscience and legal responsibility, law-abiding citizens forfeit their personal right and ability to defend themselves in gun-free zones. On the other hand, someone who is mentally disabled, who may not know the difference between right and wrong, or a bad soul who knows the difference between right and wrong, and by deliberate action chooses to harm or kill someone, they are not deterred or prevented of such actions by laws and or moral conscience. In gun-free zones, law-abiding citizens are denied their God-given right and personal freedoms guaranteed us by the Second Amendment to defend ourselves against someone whose intent to do us harm. As a wife of a law enforcement officer for 34 years, I know law enforcement personnel cannot be everywhere all the time. As a personal protection instructor with the Women's Shooting Academy and the Women's Safety Academy in Reno, I hear the stories from victims of violent crime. I teach students how to avoid becoming a victim of violent crime. Bad things can happen to good people. Within seconds, a self-defense encounter can be imminent. Essentially, the only person we can rely on to protect us is ourselves in that moment. Please, through your legislation, don't impede us, we the people of the great state of Nevada, to legally carry our firearms concealed for self-defense on the property of educational facilities and in more public areas of our communities. Thank you very much.
Thank you, Ms. Morrell. We'll now go to Mr. Tom Collins. happens to be Amanda Collins' father.
Thank you, Mr. Chairman. Approximately how much time is left?
None. So I'll give you 5 minutes, and we'll extend the opposition by 5.
All right. Thank you, sir. I'll do my best to tailor my comments.
Very good.
I thank you for the opportunity to hear this bill and finally, at last, to bring it to a vote. What a refreshing difference an election can make. You can't believe how hard it is, as a father of Amanda, to be here to testify. The further we get from this event, the more emotional I get about it. I learned at an early age that we have a couple of choices in life, one of which is, are you going to be defenseless or are you going to be able to protect yourself? When I was in law school, my parents had a friend that was shot, killed at a rest stop that used to exist east of Reno. Nothing was taken from him. He wasn't robbed. That taught me that bad things can happen to good people anytime, any place. Witness my daughter. Criminals don't make appointments. Victims aren't told ahead of time when to show up. Being a victim is not a choice. While I was angry at James Bila, I've been equally angry at the institution that rendered her defenseless when she didn't need to be. This legislature co-conspired with the university to deny her that opportunity to defend herself. One question has never been answered is what is it about the university property that is so unique that a person that functions rationally on one side of a street suddenly becomes irrational? UNR likes to brag about now being a top-tier university. So what is it? Is it like the Twilight Zone or something out of the outer limits? And if you're not old enough to know what I'm talking about, talk to someone next to you who's a little bit older. They'll explain that. But somehow these people that you talk about with gushing accolades, when they come to you for money, when they're in the presence of a firearm on campus, their minds just turn to mush. Now, what is it? Because these same people, these very same people, as Professor Lott has testified, they're no problem off campus. Why do they suddenly become irrational on campus? Why is it? And the drinking and the drugs. Do you think that doesn't happen off campus? Now, apparently it must happen only off campus because the campuses are dry, right? And we know that by passing a law, hey, it goes away. That's what's supposed to happen with gun-free zones, isn't it? No guns, no problem. Hey, tell James Bila that. Tell the person that cut up Sergeant Sullivan that. Tell the person that abducted and killed Michelle Mitchell in the 70s from that campus that. Tell their families how safe that is. How many times have I heard by the people that want to restrict the use of firearms, if it saves one person, it's worth it. Well, we know we have one glaring example where if my daughter had been able to defend herself, chances are very good you never would have heard of Breonna Dennison. And the state of Nevada would not be supporting James Bila on death row. Now, how smart of it is to think that being convicted of a misdemeanor for carrying on campus is more dissuasive than the possibility of winding up as James Bila's cellmate. Huh? I mean, why is it? What is so significant that has never been answered? The response of law enforcement to an active shooter is the same on or off campus. The problem of identifying a perpetrator versus a good guy is the same on or off campus. Don't let them off on those arguments. When they come up here after me and they want to tell you about all these hypotheticals that James Lott has talked about, John Lott, that don't exist, don't let them off the hook. They can't bring examples because they haven't happened. Despite the fact on 11 other campuses, this is allowed. Thank you for listening to my rant. But it's been very frustrating and angering all these years not to have these questions answered by the opponent. Ladies and gentlemen, it's time to allow women and others the right to choose their means of defense. Thank you.
Thank you, Mr. Collins. I sincerely appreciate all three of your testimonies today. Are there any questions at this time for any of these three? Thank you all. We are now going to go to the opposition, and we have former Attorney General Catherine Cortez Masto somewhere. I don't know. Is she in Clark County to testify? Does anybody know where she is at the moment? Aha, I think there she is. And what I'd like to do, if there are three opponents of the bill who would like to come up and occupy, they did not give me a list, so it's first come, first serve. And I will try to get at least 9 people in. We will give equal time to opposition, so we will close this hearing at approximately 5 after 11. So, Ms. Mastos, good morning. Welcome to the Judiciary Committee.
Good morning, Mr. Chair. Thank you so much. I appreciate the courtesy. And let me say, for the record, Catherine Cortez Masto. I'm the Executive Vice Chancellor for the Nevada System of Higher Education. I am here on behalf of the Chancellor, the Board of Regents, and many students, faculty, staff within the NSHE system. The Chancellor and the Board of Regents, unfortunately, are not here today because they are actually participating in the regularly scheduled board meeting for today and tomorrow. So that's why you will not see them here, but they have sent me here to oppose AB 148. And let me just start off explaining why. We believe the current law is good law. The Nevada Constitution gives the Board of Regents the authority to control and manage the affairs of the university. And case law has interpreted that to also say that the legislature may not invade the constitutional powers of the board through legislation which directly interferes with an essential function of the university. The safety and security of the students, employees, and guests on our college campuses and universities, to us, is an essential function. And we take very seriously their safety and security. For that reason, pursuant to the Constitution and the law, we have adopted policies and procedures by which we work very hard to keep our universities and college campuses safe. The adopted policies and procedures create an environment that is secure for our students, faculty, and staff. They do not require a CCW permit holder on college campuses, but there is permissive language allowing them to go to a university president to seek permission if they follow certain provisions within which they are required and need to have a CCW on campus. I will tell you, we believe AB 148 interferes with our essential function of keeping the college campuses safe. And let me say, there's been some talk on the Second Amendment, and this is not, in our perspective, a Second Amendment issue, but let me just kind of give the big picture here. Even the United States Supreme Court has recognized that schools are sensitive places where prohibitions on the possession of firearms are permitted. And thus, a majority of the states either ban concealed firearms on campus or they leave it to the colleges and universities to regulate, like here in Nevada. According to the Education Commission of the states, a National Conference of State Legislatures overview indicates that only 7 states, Colorado, Idaho, Kansas, Mississippi, Oregon, Utah, and Wisconsin, allow concealed firearms on campuses. 20 states ban carrying a concealed firearm on campuses, and 23 states allow individuals, colleges, and universities to regulate those concealed firearms. Of those 7 states that allow CCW on campus, 5 recognize that there are sensitive places on campuses that should remain weapon-free. Idaho, concealed and open carry firearms are prohibited in dorms, public entertainment facilities, and buildings with a capacity of over 1,000 individuals. Kansas, college and universities can prohibit concealed carry if a building has adequate security measures, and governing boards of the institutions may still request an exemption to prohibit CCWs for up to 4 years. Mississippi, although the trustees voted to allow guns to be carried through campus, they can be carried as long as the guns remain out of campus buildings. Oregon State Board of Higher Education retained its authority to have internal policies for certain areas of campus and adopted a new policy in 2012 that bans guns from classrooms, buildings, dormitories, and events. And then in Wisconsin, campuses can prohibit weapons from campus buildings if signs are posted at every entrance explicitly stating that weapons are prohibited. If AB 148 were to pass, Nevada would be in the minority of states, an extreme outlier on this issue of CCW permits on campuses and colleges, on college and university campuses. AB 148 is overly broad. The other thing which is very strange is right now the Board of Regents, we have the ability to adopt rules and regulations to prohibit alcohol on campus and prohibit smoking in dorms for the safety of our students and others on our campuses. But AB 148 would take our right to regulate firearms? It makes no sense. And universities and college campuses know best. You should leave the day-to-day life of these campuses to be regulated by the board, legally charged with that oversight, taking into consideration all of the constituents on those university campuses, not people working outside that do not come onto our campuses. Quite frankly, many if not a majority in the NSHE community are opposed to AB 148. It includes our administrators, our presidents, our faculties, our students, our staff. And just for the record, if there is not enough time for everybody to get up here who are here in opposition, I would like the opportunity to have everybody stand up now who is either in Carson or in Las Vegas who is in opposition to AB 148. And the reason I do that, because we have students, we have faculty members, we have those who have brought petitions with signatures in opposition of 148. This is the community who knows best within which how to protect ourselves, not somebody coming from the outside. Thank you very much, all of those who have been in attendance and have stood today. Keep in mind, the concern for all of us is that guns on campuses would have a chilling effect on academic freedom, robust classroom discussions, and already difficult, which we've already heard, faculty-student discussions on failing grades. It would also require more police presence at meetings or hearings that involve emotional volatility, such as disciplinary hearings and grade and financial aid appeal hearings. And with me today are our campus law enforcement. They are unanimously opposed to 148, and their enforcement concerns are legitimate. Let's take, for instance, an active shooter situation, which we have all talked about, we've heard about. Training in general for active shooter situations. Allowing CCWs on campuses would lead to operational uncertainties, which will confuse campus life, school police, and administrators. Currently, faculty, staff, and students are trained to report to campus police if they see a gun on campus. If CCWs are allowed on campus without any permission or knowledge by campus police or administrators, then reports of an individual with a gun on campus would immediately generate an aggressive response by our police officers who would seek to disarm the person first before ascertaining whether or not they are licensed to carry a firearm. And then what training protocols can be adopted by campus police and administrators to share with faculty and staff and students when they see a gun on campus if AB 148 were to pass? Are faculty and staff and students now required to inquire whether the person has a permit to carry concealed when they see someone with a gun? And is it fair to place that burden on them to determine if a person is a legal CCW holder or a potential predator or both? During an active shooter situation, established police response tactics call for the neutralization or elimination of the threat. Responding officers always look for anyone with a firearm in their hands or on their person. During these scenarios, anyone with a weapon could very likely be shot, including the CCW holder who may be acting as a good Samaritan. CCW training, 8 hours, does not train permit holders in how to engage and neutralize an actual active shooter. The premise that an elementary trained individual could successfully thwart an attack by an armed assailant is flawed, as anyone who has ever shot a gun or gone hunting knows. more likely that individual would pose an additional danger to other students in the area or himself. During an active shooter situation on campus, an individual with a concealed weapon could face the danger of being overpowered by an assailant. This would actually provide the assailant with an additional opportunity to gain access to weaponry and ammunition. Unlike police officers, most owners of concealed weapons are not trained to protect themselves or their weapons from the possibility. And then we've heard discussion on sexual assaults. And let me just say, I have spent many years in my career working to find solutions to stop violence against women and children and bring the awareness to the issues of domestic violence, dating violence, sexual assault, sex trafficking, and domestic homicides. However, not one of the solutions that I have worked on or come across involves arming individuals on college campuses. Why? Because the data does not support it. According to the U.S. Department of Justice, Bureau of Justice Statistics National Crime Victimization Survey, between 1995 and 2013, females aged 18 through 24 had the highest rate of rape and sexual assault victimizations compared to females in all other groups. Within this age group for victims identified as students versus non-students, the data shows that, one, the rate of rape and sexual assault was 1.0 times higher for non-students than for students enrolled in a college, university, trade school, or vocational school. For both students and non-students, about 70% of rape and sexual assault victimizations occurred either at the victim's home or the home of another known person. 51% of student rape and sexual assault victimizations occurred while the victim was away from home pursuing leisure activities or traveling to or from other places or shopping or errands, not while attending school or traveling to school. For both college students and non-students, the offender was known to the victim in about 80% of the incidences. And for student victims, offenders were more likely to be friends or acquaintances, 50%, than they are intimate partners, which is at 24%. So what does the data tell us? It tells us that sexual assaults do not predominantly occur on college campuses, and a majority of them are committed by someone known to the victim. The incident usually begins as a consensual sexual activity, but becomes non-consensual for many reasons. And oftentimes, alcohol and intoxication are involved with both parties partaking. In this situation, the chances that a victim would be within reach of a gun or even of a rational mind to use it would be very low. Gun rights advocates have co-opted this important discussion about preventing violence to women and children and redefined it to suit their agenda. AB 148 is a perfect example of how those tone deaf to the issue of preventing violence against women and children continue to distort the policy discussion to suit their needs instead of the needs of the women and children many of us have been fighting to protect over the years. To obtain a CCW permit under Nevada, you also have to understand, and you really have been told today, that you have to be 21 years of age. We all know that. But many don't realize of the students attending NSHE institutions, 36.4% are under the age of 21. That's 373 students on our campuses who are under the age of 21. And preschool age children, there's 483. Elementary school children on our campuses, 681. And high school students attending programs at NSHE campuses, 2,896. AB 148 does not help to protect these students. Instead, it gives predators an additional tool to use to prey upon them. We've all heard already talk about alcoholism and the use of alcohol on college campuses. The 2013 National Survey on Drug Use and Health indicates that college students aged 18 to 22 who were enrolled full-time in college were more likely than their peers who were not enrolled full-time to report current binge or heavy drinking. Among full-time college students, 59.4% were current drinkers, 39% were binge drinkers, and 12.7% were heavy drinkers. And according to the National Institute on Alcohol Abuse and Alcoholism, abusive and underage college drinking are significant public health problems for students between the ages of 18 and 24. About 4 out of 5 college students drink alcohol. Each year, an estimated 599,000 students are unintentionally injured under the influence of alcohol. Each year, an estimated 696,000 students are assaulted by another student who has been drinking, and 97,000 students are victims of alcohol-related sexual assault or date rape. On NSHE campuses, there is a zero tolerance for underage drinking. That is different than a dry campus. There is confusion, and I've heard discussion about this being dry campuses. We have a zero tolerance for underage drinking. Yet we all know alcohol finds its way into the hands of our underage drinking. But alcohol beverages are sold during university athletic events and at parties and campus venues for those of legal age. And I've just identified many on our college campuses are going to be 21 years of age or older. So there will be alcohol legally sold to those individuals. However, the combination of alcohol, individuals carrying firearms, and binge drinking can be potentially lethal. And then the allowance of concealed weapons on campus without any limitations would increase the potential for accidental discharges of these weapons with resulting injuries and fatalities on campus. We have a perfect example. If you just open the papers and read the Idaho State Journal, an instructor there accidentally shot himself in the foot in front of his class carrying a concealed weapon. Most importantly, campus requests for CCW permits have been de minimis for the last 3 years. Again, this is a solution in search of a problem. Some questions that I would like you to consider. How would dorm students safely store their weapons? Would they leave them unattended in their rooms? What if their dorm partners objected to the weapons? Would the university be obligated to provide storage or change the dorm room occupants? Would CCW permit holders be able to bring loaded firearms to university-sponsored hosted events where political candidates or office holders are in attendance or speaking? And what about controversial speakers, student, staff, disciplinary, or human resource hearings? All of the things that you've heard about that we have concerns about. Again, why are we passing a law that benefits a minority instead of the majority of individuals who are attending our campuses who have legitimate concerns about CCW? Providing for campus safety is an essential function of the NSHE, which is constitutionally controlled and managed by the Board of Regents. As such, the Board has adopted policies to provide for the safety and security of its students, employees, and guests on each campus, and to create an atmosphere of respect, friendliness, and community on the campuses, and to provide the most efficient, extensive security for each campus within the resources available. The regulation of firearms on campuses is an important function of our campus safety policies and best left to the discretion of the Board of Regents as recognized under current law and best practice across the country. And finally, let me just say what I've heard today. If CCW permits and the law with respect to them is changed under AB 148 as it applies to campus life, but it is not changed according to what I just heard in the legislative building, then what are we saying to our parents and students as opposed to the concern with respect to their safety and allowing guns on campuses, but we do not allow them in legislative buildings to protect our politicians? So if we really are concerned about this issue, let's focus on the data and what it tells us. Thank you very much. I appreciate you hearing me today and listening to many of our concerns, and I'm happy to take any questions.
Thank you, Ms. Mastos. We have several questions for you. We'll start with Mr. Araujo.
Thank you, Mr. Chair. General Masto, thank you so much for being here today, and thank you for working so hard to create an environment that's conducive to learning. I have a quick question. Are you concerned at all that this bill and this policy would make it less attractive to prospective students who are looking into Nevada public schools? And furthermore, are you concerned that this may impact our retention rate when it comes to the top faculty that we want teaching our students?
From my perspective, yes, those are absolutely two legitimate concerns. And I think you have the opportunity to hear directly from current students and faculty on those considerations. So that's a great question.
Thank you.
Mr. Gardner?
Thank you, Mr. Chair. I've actually got a couple. To follow up with that,
we're limited to one.
Yeah.
If you want to roll it into two points in one question, go ahead.
You kept talking about the data, and I thank you for that. That's what I've been looking for. You kept talking about how this would happen or how this would happen. I'm looking for evidence of that. You said that it would cause us to lose faculty. There are a lot of other states that the campus carry, and is there evidence that they are losing faculty? You said it would cause negligent discharge. Do we have evidence that negligent discharge would hurt people? Drinking alcohol, do we have evidence that students in the other states are killing each other because they have CCWs on campus? All these claims you were making, I'm looking for evidence on those. As far as I've heard so far, I've not received any. Do you have evidence to back up what you're saying, or are they just your thoughts or what ifs?
Thank you, Mr. Chair, to the Assemblyman. So the first question you asked me, I did not have in my statement. That was a question as posed to the previous Assemblyman, and I said those are legitimate. That's a legitimate concern about the students and faculty attending a college campus that has CCW, and you should hear from the faculty and staff that are here today. So I would leave that question for them. With respect to negligent discharge, yes, perfect example. We have a faculty member in Idaho who shot himself in the foot in front of the classroom. So if you want an example, there it is. From my perspective, the concern should be not about what does the data show us with respect to guns when they are on campuses. It should be more concerned about the safety in general of our students when it comes to all of the variables that are impacting them on our college campus life. It's not just about the guns. It's about the alcohol that's introduced. It's about unfortunately, what we hear, the sexual assaults that may occur, whether you're on campus or off campus. It has to do with suicide rates that we know that particularly at a national level, our college campuses have some of the highest suicide rates. So you can't just look at it in a vacuum. It's taking all of those variables together. And from that perspective, that's why the system, the faculty, the staff, the president, the administrator, the Board of Regents, we are in the best position to say what is appropriate when it comes to securing our campuses, taking into consideration all of those variables. At the same time, I will say this law is good law now. It takes the safety into consideration, but it also recognizes that Second Amendment right when it comes to CCWs, because it gives a pathway for somebody who does want to carry the opportunity to ask permission to talk to somebody about being able to carry concealed on campuses and being allowed to do so if they fall within the right criteria. So those are the concerns that we have.
Ms. Seaman?
Thank you, Mr. Chair. I've heard in prior testimony in a judicial hearing regarding gun laws that you have approximately, and I'm asking you this, 2 to 4 officers per day at UNR to protect about 10,000 approximately students per day. So what practice or protocol do you have right now in place to keep non-CCW holders or criminals, gun carriers off your campus right now to protect those students?
Mr. Chair, thank you to the Assemblywoman. Actually, your data is incorrect. I'm not sure where the previous testimony comes from. There are more officers than that. And what I would ask is there is a representative from UNR Police, if that's the campus you're referring to,
yes,
up there in Carson City.
It was the chief.
Who can come forward right now. Okay. Perfect. Can come forward right now and give you statistics on the total number of peace officers who are armed. But it's not just bodies. It's other areas that we use to secure our facilities and the technology that we use to help us, because we, of course, can never be everywhere with human resource. So I'm going to ask Mr. Renwick, who is there, I believe, to answer your question.
Actually, he'll have a chance. He's sitting at the table to testify, so we'll go to him when we've completed. Actually, I want to stay in Clark County for a little bit, in that we've completely neglected the folks down there, giving them an opportunity. Is there any further questions? Mr. Anderson, you had a question?
Thank you very much, Mr. Chairman. Good morning, Vice Chancellor Mastow. It's great to see you again. I was thinking about this, and first of all, thank you for clarifying the issue about dry campuses versus zero tolerance. As any UNLV student knows, there's a lot of bars right across the street. What I was thinking about when we were talking about all that and we were talking about guns, I've worked a lot on suicide through my work with veterans, and it's on my mind because I know that college students in general have higher rates of suicide, and that when you introduce weapons into the equation, you have higher rates of completed and successful, excuse the term, suicides versus other types of methods. And so what I'm wondering, have your psychological services, have they actually thought about how this could impact suicides on campus by forcing guns onto the campus environment?
Thank you, Mr. Assemblyman, for that great question. Yes, this is always a concern of ours. When it comes to any type of prevention, intervention, education awareness for social issues that are impacting our students, we always work very hard to ensure we're pushing that information out there. Do we do the best job at it? Probably not. But yes, suicide rates, when we know nationally, and I don't have the statistic, but there is a professor there in Carson City, Dr. Aaron Gristein, who has the research on this data, who is ready to testify in opposition to this bill as well. But yes, that is a concern. The high suicide rates that we see nationally, of course, when it comes to those on college campuses, we are going to do everything we can to ensure that we address any variable. If AB 148 is introduced and now firearms are allowed on our campuses, it goes back to the same question. It is going to require us to really consider where they're going to be allowed, where the students will be carrying them, and how they'll be utilized. And now taking a new factor into that is the issue of unfortunate suicides that may be involved as a result of it.
Mr. Jones?
Thank you, Mr. Chair. My question is pretty direct. It seems to me that most of your testimony is very general, like we just had the suicide. When you were talking about rape, you were talking about most specifically people that know each other in their own homes or friends' home and stuff. But the statistics that came out earlier by Professor Lott were very specific to CCW holders, and we're talking about a very specific issue. We're not talking about general suicide. We're not talking about rape at home with somebody that's known. So when we ask very specifics, it doesn't seem like you have any specific stats having to do with CCWs. And if your police officer's so available, where was the police officers when Amanda Collins was raped 50 yards or whatever, where she could see the police car? And yet, why are you so opposed to responsible people in a very specific category that have gotten trained be able to defend themselves?
So thank you, Mr. Assemblyman, for the questions. I can't speak to the issue with respect to the testimony of Ms. Collins. I was not there at the time. I don't have the specific data there. When you're talking about specific data with CCW that Mr. Lott is referring to, I'm not sure that I agree with you. I did not see specific data. It was very general in nature. And the reason why he doesn't have very specific data is because the data that I identified just previously. Many of the college campuses do not allow CCW. And there's a reason for that. And so why are we trying to force an issue that does not exist? That was the point of my comments. When we talk about those college campuses that allow CCWs on college campuses, there's only 7 states. And 5 of those 7 still prohibit them in sensitive places. So why are we doing an overly broad allowing CCWs everywhere on our campuses when there doesn't seem to be data to support the need for it? And that was my point.
Ms. Mastos, I have to ask a question along that line. You did cite some data. You actually stated there was one case in Idaho where a professor shot himself in the foot. Could you elaborate beyond that single point, please?
No, and I did not pull the data to do so. If you would like me to do so, I am happy to do so.
Well, we're going to have some other folks testify, and I'm definitely interested in data. So we have several more people who have questions. Mr. O'Neill?
Thank you, Mr. Chairman. Ms. Mastos, I've got a question, and it's relating to NRS 202-3673, and if you'll indulge me, paragraph 4C, it says that a permittee who is employed in the public building from carrying a concealed weapon while he or she is on the premise of the public building allows a employee to carry in a public building, and it describes that a public building is a public building means any building or office space occupied by any component of the Nevada system of higher education and is used for any purpose related to the system. Then it goes on to explain some others. Why is NSHE currently putting a blind eye to this statute and not allowing some of their employees, and then going under 202 it's in conflict with 202.365 and not allowing them to carry their firearms, their CCW, when they have CCW permits in their place of employment, where other state employees are allowed to?
Thank you for the question. I actually read that statute differently than you do. If you read NRS 202.3673(4), if you read the first provision of it, it says, "For the provisions of paragraph B of subsection 3 do not prohibit," and then it goes into A, B, C, and D. So 4 is only referring to paragraph B of subsection 3, which is a public building, right? Mm-hmm. But if you look above that, a permittee shall not carry a concealed, in actually section 3A, which is very specific, it says a permittee shall not carry a concealed firearm while the permittee is on the premises of a public building that is located on the property of a public school or a child care facility or the property of the Nevada system of higher education. So 3A is very specific, does not allow it. 4 refers to B, which is a public building. In that instance, if you look at the A, B, C, and D, it's actually really referring to courthouses because they're identifying that in those buildings, judges, prosecuting attorneys, and employees who work in courthouses, I suspect that's what they're referring to, are allowed. So the reason why we interpret that section as disallowing concealed firearms is because 3A is the specific provision that does not allow a permittee to carry a concealed firearm in or around on NSHE campuses. Does that make sense?
I think we'll agree to disagree. Thank you.
Mr. Wheeler?
Thank you, Mr. Chairman. General Mastos, just a couple of quick points, if I can, on the data that you were presenting. Can you tell us how many permits are actually issued in our system of higher education, say over the last year, for CCW holders who go through the process at the schools? And also, I don't believe anyone ever actually answered Assemblywoman Seaman's question. How many police, I'm sure you have the data, how many police officers are there, or I should say how many students per police officer in our system of higher education?
Thank you for the question. So as to Assembly Seaman's question, I had asked that UNR representative, police Todd Renwick, testify, and I don't know if you recall, but the chairman said he will come up to testify to that specific issue. So with respect to the carry concealed on our college campuses, I will tell you just last year, the statistics that I have, the request for carrying concealed weapons on our college campuses, UNR, the request was for 9. There were 9 requests that year. 4 of them were non-gun related because it's for weapons in general, and 5 of them were for guns. On our college campuses. That's just UNR. UNLV, there were 3 requests last year. TMCC, there were 6 requests, and those were last year the only looks like, WNC had one request. And so breaking those down, I'm sure the follow-up is how many were denied and how many were approved. I'm assuming that's where you're going. So
Go ahead and
UNR,
answer. That's what I asked,
of the 9 at UNR, it looks like that 4 were denied and 4 were approved. 5 were denied and 4 were approved.
Thank you. Any further questions? I have one, actually. You mentioned that CCWs, if allowed, would have a chilling effect on academic performance. Now, I know that the state of Utah, which has numerous college campuses, I would suspect at least 100,000 students there, they have full-on campus carry. I'm just wondering if you have any information or data that suggests that they've had an academic decline in their overall performance after the introduction of CCW laws.
I don't have that, but what I do have is the actual data from our faculty who have concerns, and I think that's something we have to consider. Their concern about the chilling effect it would have, and they're here to testify, as well as the students who participate in a lot of the discussion on our college campuses. That, to me, is the hard data that we look at as to how we keep our campuses safe. We cannot ignore their concerns.
But so basically, you're saying you have no data from all these other states that allowed it that have actually seen a decline in academic performance. Thank you.
I don't have the data, but I'll be honest with you, I have not looked for that data. If you would like me to look for it, I'm happy to do so.
Well, I have several people who want to test. I'm hoping to get some data out of the opponents of the bill. So, Ms. Maslows, are there other people there in Vegas next to you I can't see that would like to testify at this time? I'd like to give Clark County an opportunity. All right, you two.
Yes, there are a number of people.
Thank you very much for your testimony and your willingness to answer our questions. We'll go down there now, and for the folks, why don't we start with the one on your right, Ms. Mastos?
Good morning. My name is Frank Slaughter, and I'm a former UNLV boxing coach and a parent of a UNLV student. I would like to urge you to oppose AB 148, as well as any other bill that would allow guns on campus. I have attached articles and research describing the myriad of reasons why campus carry endangers our students. We have heard the quote, if it isn't broke, don't fix it. Common sense tells me that AB 148 is a bill that aims to fix a problem that doesn't exist. While sexual assaults is a growing problem around the country, no evidence has proven that allowing concealed carry in any ways would reduce that crime. And in fact, gun crimes on colleges are significantly lower than the general public. Concealed carry will not aid to the sense of being safe on campuses, but will do the opposite by taking away the idea that campuses are sanctuaries of free ideas by stifling intellectual debate. We have also disclosed that the cost of campus carry in Texas, it would be estimated to cost $47 million. In Idaho, as we've talked about this state before, it ran the university system $3.7 million 1 year. While the numbers are still being compiled for the estimate cost of Nevada, I assure you that the cost to this measure is not only in lives, but would also would endanger in lives that it would endanger, but also the economic cost to our students and the educational system as a whole. I ask you to oppose AB 148. It will further burden our college and universities with undue costs that have to be passed on to our taxpayers as well as their students. Every campus security officer I've spoken to with on UNLV and CSN are not in favor of this bill. It would make their jobs more difficult. I have also interviewed myself over 200 students and found a vast majority that don't want campus carry, as well as with a handful of professors and staff that I've spoken with. Some professors have even mentioned that they would resign in protest. Here you can find, here I have photos of over 100 students on UNLV and CSN that voiced their opposition to campus carry. We have also gathered over 1,000 petitions voicing the opposition. If you like, I can make this available. I'm sorry I didn't have it today. I'm frustrated that it frustrates me that various members of our legislators do not understand how foreboding a bill like 148 would be to our campus community. And it's like this. They don't understand or they don't care. My purpose is to garner your support to stop AB 148. I hope that my testimony here today persuades you as our lawmakers to not have this bill enacted. Thank you for your time, and I hope this bill dies in committee and good common sense will prevail. Thank you.
Thank you, Mr. Slaughter. Any questions for Mr. Slaughter at this time? I actually have a question for you, Mr. Slaughter. You mentioned that campuses are sanctuaries. Now, you said that this would create havoc apparently of some sort. I'm curious, out of all the other states that are doing this right now, including our sister state of Utah, which has had these same laws for almost a decade now, do you have any evidence to show that there is in fact an increase or even a single instance of violence or something that has actually disturbed the sanctuary aspects of the Utah campuses or the other ones in the West, with the exception of the one professor that shot himself in the foot?
No, I'm sorry. I didn't do any research in that area, but I can tell you that guns are incompatible to education. That's all I can say on that matter.
Thank you, sir. Mr. Jones has a question for you.
Thank you, Mr. Chair. In your testimony, you represented that millions of dollars would have to be expended in the event that this campus carry bill goes through, and you referenced multiple places, but you didn't say what would be expended, because on our fiscal note analysis by our legislative bureau, there's no fiscal note, meaning no extra expense as a result of this bill. So what are you citing, all these multiple millions of dollars that will have to be expended if this campus carry bill goes through?
Well, there are articles that I did read, and that did state that in Idaho alone, there was $3.7 million that was incurred to the university, probably in a liability cases with the, insurances. I'm just a regular person. I'm not a professor or part of the university system, but this is what I read. And there's also one that states that $47 million has been spent in the University of Texas in Houston system alone for liability costs. I can provide that article to you if you like.
Mr. Anderson?
Thank you, Mr. Chairman. I wanted to clarify with you, Mr. Chairman, were we able to ask one question per witness? I just feel like what's going to happen is we're going to run up and not have the opposition get as much time, so I was hoping we could clarify that and maybe even ask for another hearing to get more testimony in.
Well, actually, I had the same rules for everybody from the beginning. If you wanted to ask questions of every single witness, I gave everybody on the committee an equal shot. I have limited it to one per person, per witness. So I don't think we're doing anything here to the opposition, and the fact is that Ms. Mastos took about 35 minutes in her testimony. However, she was specifically requested by the University Regents to be their lead-up witness, so we're trying to be fair to both sides. Mr. Orenshaw, you had a question?
I do, Mr. Chairman. Mr. Slaughter, thank you for coming. We appreciate getting input from parents. If this law passes, do you believe that you and your daughter will consider transferring out of state or transferring out of the Nishi system?
No, I don't think I would, take my son out of the university system because if this law passed. But I can tell you it would be an unsettling law and it'd be an unnecessary law if it did pass. There's no problem on UNLV campus, and if it's not broken, why fix it? This bill to me is all about the NRA and the gun lobbyists trying to push stuff down on our throat that we don't need. Period.
Thank you, Mr. Slaughter. I don't see any further questions for you at this time. I'd like to go to whoever was on the left of Ms. Mastos up there and give them an opportunity to testify. Good morning. Go ahead and state your name for the record and proceed.
Good morning. My name is Nadej Bartholomew. I am a former active duty Air Force member, and currently I am the UNLV Black Student Organization Vice President, and I oppose Assembly Bill number 148. My deepest sympathy goes out to Amanda Collins. I definitely understand her anger and belief that if she would have had her gun on her, the events that happened on that unfortunate night might have been different. Like her, I am a mother, I am a student, and I am a woman. Unlike her, I do not believe that this bill is a solution to preventing crimes. As a law-abiding citizen myself, Amanda Collins does not speak for me. Neither does Nevada Assemblywoman Michelle Fiore, Senator John Lee, or any other supporters of this bill. As a veteran trained in handling guns and assault rifles who served in Iraq in support of Operation New Dawn and Operation Enduring Freedom, I am a first-hand witness to even the best and brightest losing their better judgment when it comes to handling a gun. This bill is a representation of what is wrong with America. America has a huge issue with the application of appropriate use of force and exercising de-escalation measures. This is apparent in cases like the state of Florida versus George Zimmerman, and that involving the murder of Jonathan Farrell, a young officer, Jonathan Farrell, a young man who was shot 10 times by a police officer while attempting to seek help after his car hit a tree. Please note that even police officers who are trained still have issues applying appropriate use of force and implementing de-escalation measures when their perceived fear overcomes actual circumstance. In accordance with NRS 200.130, bare fear is insufficient to justify killing. The goal of this proposed bill is to arm people with guns in elementary schools, people with guns in middle schools, in daycares, colleges, and universities. Uneducated and untrained civilians, motivated by their perceived fear, will be cocked and loaded to pump lead into any students. Assemblywoman Michelle Fiore believes this bill is a women's right issue. She believes if women like myself, or as she puts it, hot little girls, were allowed to carry firearms into class, it would deter perpetrators because they'd be too afraid of getting a, and I quote, a bullet in their head. It must be fun to live in this pretend imaginary world that Fiore has contrived. Fortunately for me, I live here in the real world. And I know that the same right that would have allowed these little girls to carry a gun into elementary, middle, high, college, and universities would also have allowed perpetrators to carry guns too. Assemblywoman Fiore is a self-described conservative, Catholic, gun-toting, Second Amendment, strong-ass woman. She doesn't care about women or the law.
I'm going to have to interrupt you. Please keep on the topic. No personal ad hominem attacks. Let's stick to the issues, please.
Okay. The reality of this bill is that teachers will now have access to guns at an elementary school. Teachers will have guns at middle school. Care providers will be allowed to have guns in daycares. In addition, instead of assisting law enforcement and school officials who are both law officials and school officials who are both against the passage of this bill, we would rather engage in victim blaming. Public safety is the job of law enforcement. This bill makes it harder for police officers to discriminate between criminals and a victim. In the event that police were called out to a school shooting, in those crucial moments when perceived fear takes over, there would be no way to identify the assailant from someone who might have just happened to have their guns out. Due to these reasons, I urge all of you to vote no on this bill. And if you are strongly in favor of this bill, vote no. Then reinvest your energy into helping law enforcement to make our community safe again. And just to answer Vicki Kalmiker's question about possible alternatives to this bill, I would like to point out a statement as testified by Professor John Lott, who testified that a person who did research did not choose a particular place because there was a lot of police force out there. So I would encourage, as an alternative, to look into increasing police presence to deter perpetrators. Thank you.
Thank you, Ms. Bethany. We do have a question for you. Mr. Gardner?
Thank you. Just one quick question. You're talking about how cops wouldn't be able to decide who is a CCW holder and who is not. Currently, when they're not on campus, cops have to do that every single day. Are you saying that they lose that ability by crossing over onto a campus?
Yes, I am saying that because I don't know if you've walked down our hallways. They're very small, they're very narrow. And if you walk into a building as a police officer and you know there's a shooter on campus, you're looking for a shooter. You're looking for someone with a gun. So if somebody with a gun walks out into the hallway, there in those couple seconds, there is no way to determine whether that person is a CCW carrying person or the active shooter. And those moments are very crucial to police officers. Because that is the difference between a bullet in their head and a bullet in the head of a perpetrator.
Thank you, Ms. Bell. I have a quick question, same one I've been asking everybody else. Everybody's making a lot of very broad generalizations as far as actions on other places. Can you give me a single example? We have numerous states that allow CCWs on college campuses of one case of any of the hypotheticals that you've mentioned. People being shot, kids that are drunk or anything like that?
I'll give you my experience with weapons. I've been
on a college campus now. On a college campus.
Just somebody who was licensed to carry a weapon, yes.
On a college campus.
Someone licensed who was. No, I don't live on a college campus.
I know, but I'm asking a question. We're talking about CCWs on a college campus. In many states, it's allowed. I want to know if anybody is going to give examples of people that have been physically harmed by somebody carrying a CCW on a college campus in all these states that allow it. Is there an example of that? I know it goes on the streets.
I don't live on the streets. I have a home. With respect to your question, this bill is not just about college campuses. It's about elementary schools as well, middle schools, daycare facilities. My son goes to an elementary school, and I do not want him in the same classroom as a gun. Okay. I don't allow guns in my house, and I do not want guns in my son's classroom.
Thank you very much. Still haven't got the data, though. Ma'am, who is on your right? Would you have them testify? Thank you.
Yes, sir. If you would like data, I can come back with some. Thank you, sir.
Thank you, I would. Could you have the individual to your right testify at this? Yes, sir. You, sir, please testify at this time. State your name for the record.
My name is Derek Washington. I am the chairman of the Black Democratic Empowerment Project here in Clark County, Nevada. A lot of this, you keep asking for facts, and I'm going to be perfectly honest with you. I'm not a person who can quote chapter and verse of the Bible or laws, but I will tell you a few facts. The fact is that I am a 6'1", 220-pound black man. My fear is that if I'm at UNLV or UNR and I rush up to a woman who maybe is about to drop something and she's carrying a loaded weapon, she will feel threatened and shoot me. I'm afraid of a father who maybe is going to deliver cookies to his toddler's school and has a gun in his backpack. Another toddler grabs it and shoots the toddler. Those are what I'm afraid of. I was held hostage to the young lady who was raped. Oh my God, I feel so bad for you. I was held hostage by 3 drug addicts, held with guns and knives to my head. I still can't sleep with the lights on. Every day I suffer, and I'm sure you do too. I'm sure every time you close your eyes, you relive those moments, as do I. Having said that, the people who held me hostage didn't give me time to go get my gun. They didn't give me time to unlock the case. They didn't give me time to load the gun. And I just don't see where having guns in schools and around children and around students is going to give anyone the clarity of mind to grab their weapon and defend themselves or defend others. It's a nice theory, and when we talk about data, how many people actually have been able to think clearly in situations like that and do something? Many, many times I thought to run for the door. The one time I did, they grabbed me, they threw me to the ground, and they told me if I did it again, they would kill me. So honestly, this is sort of a made-up issue. Lastly, what I'm really fearful of, more ashamed, is that we're sitting here with so many things going on in this state that need to be fixed, our roads, our environments, our schools, and we're sitting here and trying to give people who feel that they have a God-given right, as one lady said earlier, to carry a gun on campus. I'm not afraid of that. I'm ashamed of that. Thank you.
Thank you, Mr. Washington. We have some questions for you. Mrs. Seaman?
Yes, thank you, Mr. Chair. You have a lot of fear, so I'm just wondering if you're afraid of of campuses being a gun-free zone, that it may attract someone who wants to do a mass shooting. Does that scare you at all?
I'm afraid of anyone anywhere who wants to do a mass shooting. And no matter what laws you put in place, look at Norway. A guy killed 91 people there, and they don't allow guns. So to be perfectly honest, he was on a mission to kill people. So my point is this: if a person is bound and determined to do this, they're going to do this anywhere. Why do we need to have guns everywhere? Why do we have to have guns in the places that are supposed to be safe for people, safe for our children? Why? You just foster the idea that guns are normal and guns are good and guns can be everywhere. That's not right. You basically tell little kids, here, have a gun. It solves all your problems.
Thank you, Mr. Washington. I do have one quick question. The God-given right may have been a little bit extreme, but do you believe we have a Second Amendment constitutional right to own firearms in the United States?
I actually believe that anyone who wants a gun and goes through the proper process should have a gun. I think that I don't necessarily know exactly what the Founding Fathers meant in the Second Amendment. I believe they were talking about militias to protect the country. Having said that, I feel if you are trained and you can get a license and you can go through all the things that you have to do to get a gun, go for it. And be responsible about it. But that doesn't mean just because you've had the training and because you have the license, and because you've done all this stuff, that you're not going to one day snap and take your God-given right to a school and shoot someone. So, yes, I do agree that people have the right to have guns in this country, and until some higher force than I says differently, absolutely, with the right training.
Thank you. Mr. Gardner?
Thank you, Mr. Chair. Just a quick question, basically the one I asked earlier. You said you have fears about these killings possibly, or kids getting their hands on guns if they're brought on campuses. Do you have that same fear not on campus? If you cross the street, do you have that same fear, or is it only on campuses?
I have that fear anywhere someone feels they have a God-given right to have a gun. Honestly, at Kmart, at Costco, at UNLV, at 7-Eleven. Yeah, I got a fear of people walking around loaded for bear and with a chip on their shoulder about God. Yeah, absolutely.
Okay, thank you very much, Mr. Washington. We're going to come back up north now at this time, and we'll start with you, sir, on my right. Thank you for your patience.
Thank you very much. I'll try and keep it quick. I know we're running out of time here, and there's a number of other people that would like to testify. Good morning, Mr. Chair, members of the committee. Thank you for allowing testimony today on this very, very important issue. My name is Caden Fabi. I currently serve as a Speaker of the Senate for the Associated Students of the University of Nevada. I'm here today to present the resolution that was passed on February 25th, 2015 in opposition of Assembly Bill 148. I've submitted the resolution to the committee for your reference. The Senate stands with the administration of both the University of Nevada and Nevada system of higher education in the sentiment that guns do not belong on NC campuses for the following reasons. 1. The current system to allow persons to carry a concealed weapon on campus, the president's discretion, is appropriate. No one knows a campus, and thus whether or not concealed carry is appropriate in certain situations on that particular campus more so than the president of the institution. 2. According to the Chronicle of Higher Education, there is no recorded instance in which a victim or witness to a violent crime on a college campus has prevented it by brandishing or using a gun. Further, why should a student feel that they need to carry to feel safe on a college campus? 3. The insinuation that sexual assault on college campuses will decrease or end if this bill were to pass is wrong. There is no proof to back this claim. The CDC's Division of Violence Prevention does not recommend additional guns to protect individuals from sexual assault. Rather, it says that preventing sexual violence perpetration before it happens will achieve the greatest population level impact. Effective prevention strategies are comprehensive, addressing the multiple levels of influence for sexual violence, victimization, and perpetration in the social ecology. These levels include characteristics of individuals, their relationships, and their physical, social, and cultural environments. To decrease the amount of sexual assaults on our campus, we hope to educate the students on what sexual assault is and how it most often happens. According to the Bureau of Justice Statistics and National Institute of Justice, in the vast majority of cases of sexual assault, the victim knows their perpetrator and thus will be unlikely to brandish a gun in the situation anyway. This was proven on our campus in a recent survey that went to the student body regarding the sexual assault climate on the University of Nevada campus. It found that 80% of incidents occurred off campus and 80% of victims knew the perpetrator prior to the incident occurring. 4, the majority of college students simply do not support campus carry legislation. The proof of this is in a poll that was conducted recently by the New York Times, which showed that 67% of males and 86% of females are opposed to campus carry. 5, in the case of an emergency situation occurring on our campus, first responders could have difficulty differentiating between an active shooter and a student legally carrying a concealed weapon. The training required for a citizen to obtain a concealed weapons permit does not necessarily mean that the person is able to react in the case of an active shooter being on campus, as opposed to professionals who have been trained in crisis situations. 6, the Associated Students of the University of Nevada, in conjunction with the university, has created several successful campus safety programs, including a blue light emergency call system and campus escort, which will give any student on campus a ride at night to their home or car within a 3-mile radius of campus. 7, institutions of higher learning should be a place where diverse ideas are shared in a free-flowing manner, and adding concealed weapons to the picture would detract from this. 8, the Senate is concerned with the fiscal impact. When campus carry was passed in Idaho, the universities there spent millions of dollars in additional security measures. Recently, as you all know, a 17% tuition hike was approved by the regents. The Senate supported this, under the assumption that those funds would be allocated to hiring tenure-track faculty and lowering the faculty-to-student ratio, not for the need for additional security measures because of a campus carry bill. And finally, you must be 21 years of age to obtain a CCW in the state of Nevada, so this bill would only allow for a percentage of our student body to even carry. Students under the age of 21 could feel defenseless on a campus where only older students, who are also allowed to drink legally, can carry. I, on behalf of the Senate of the Associated Students of the University of Nevada, strongly urge this body to oppose Assembly Bill 148. Thank you for your time. I'm going to ask that the other two here give their testimony, as well as some others, rather than accepting questions from you guys. There's a number of people that would like to speak.
Thank you. I'm sorry, actually. I'm the chairman. I'll make that determination. We have some folks that would like to ask you some questions. Sure. Mr. Thompson, go ahead, please.
Thank you, Mr. Chair. I want to thank you so much for being a leader in your college campus, and most specifically for doing your polling, so you're not just anecdotally, you're actually asking the students. So I appreciate that. I have a question. If this were to pass, if this legislation were to pass, did you all talk about what that would look like? Kind of the question about that we asked the parent, would some of the students think that would they reconsider going to other campuses in the, if this legislation is passed?
Thank you again. My name is Caden Fabi, for the record. I can't say with absolute certainty, but I do feel that there are students that wouldn't come to this campus, and I think there are some that are here today that would choose not to go to a university in the Nevada system of higher education if this bill were to pass.
Mr. Wheeler?
Thank you, Mr. Chairman. Thank you for coming today. You cited a New York Times poll. Was that taken in New York, or was that taken here? And if so, no matter where it was taken, do you know what the sampling was? Do you know how many children, or how many students, I should say, actually participated in the poll? I know I didn't usually participate in those.
Thank you for your question, Assemblyman Wheeler. Again, my name is Caden Fabi, for the record. I don't have that specific information on me right now, but I'd be happy to provide that. In addition, I know that that Ms. Cortez-Masto provided some information as well earlier today, statistics, and so I'd be happy to provide any information that you request.
Thank you. I'd love to see it.
Mr. Gardner?
Sorry, just real quick. You mentioned that the poll, and assuming that's correct, are you saying that rights should be determined by the majority, and all rights should be determined by the majority, or just in this case?
I think that each and every one of you, sorry, again, my name is Caden Fabi. I think that, I experienced this even as a senator when making decisions, tough decisions that impact students, right? Am I going to go directly with what the student body thinks, or am I going to go with what I think is best? And I guess I have to ask, if there was any formal polling done between your constituents. I think that people are deeply, deeply concerned about this. And it's not a laughing matter. I think that people are, deeply concerned about this across our state. And I would encourage that.
Thank you. Ms. Diaz, you had a question?
Thank you, Mr. Chair. And I just want to remind everybody on this committee that it is our responsibility as legislators to imagine possible harms without having hard data. And I also wanted to ask if you knew a lot of the proponents of the bill were citing the information from the professor and his book, but have you also read the scrutiny over this data? Because entities like the Washington Post, they have weighed and checked in and balanced on this hard data in that book as well. So did that come up in your conversations?
Thank you for your question, Assemblywoman Diaz. Again, my name is Caden Fabi. We didn't have specific conversations about that book, but I can imagine that there have been some critical remarks on it. I haven't, read that, but I will. Thank you.
Thank you very much. Seeing no further questions, we'll now go to the officer in the middle.
Good morning. I am going to try to streamline this as well so I can let others get up here.
Well, we have 5 minutes, and I'd like to go to you two, and then at least give one more person in Clark County an opportunity. Then the hearing will be done. It'll be equal time, equal numbers for both sides.
Okay. Again, my name is Todd Renwick, and again, good morning, Chairman Hansen. Thank you, members of the committee. Again, I'm here on behalf of Adam Garcia, the Director at Police Services. As you've heard, most of our higher administration are at the Board of Regents meeting conducting business today. But I am here to testify in opposition, and I do want to point out some things that we've heard come up. You're right, I can't give you specific data, but I think Assemblywoman Diaz kind of said it right. I don't want to be the campus that has to have the data now to show you. But we have to keep in mind that we have tens and thousands of students and community members that descend on these campuses every day. We do have large-scale public events. We do have venues that host thousands of people for sporting events, concerts, career fairs, conferences. Unlike most of what you see, we do have unsportsmanlike conduct that does occur at these athletic events, and oftentimes, if not in most of the cases, alcohol is fueling those unsportsmanlike behaviors. We also have rivalries that we deal with during these sporting events, and we just don't want these types of environments to potentially become killing fields if something goes south during an event. It should also be noted, alcohol is widely used around our campuses. To give you to put this in perspective and for the demographic that we serve, we have cited or arrested over 260 students for alcohol incidents on our campus. This is in 2014. We all have heard suicide issues. Suicide is the leading cause of death among college students in the United States. We got about 1,100 successful suicides on college campuses and an additional 24,000 attempts every year. And we do know that when a gun is used in those attempts, more than 90% of the time it is fatal, compared to the 3% fatality rate for suicide attempts by drug overdoses. And again, I do want to point out an initiative, and you'll hear my colleague also talk about this. We did do some polling on our campus. We did a recent survey in November 2014. It was a survey for on our university on sexual conduct and campus safety. It told us that generally students feel safe on campus. Most occurrence of these unwanted sexual contact acts happen off of campus. Many of our key findings also reflected the trends that you always hear, that sexual assault is vastly underreported, but we also know that the victim most often knows the perpetrator in 80% of these incidents, and we also want to point out that 33% of these incidents involve alcohol and drugs. We do have a duty. You've heard our Vice Chancellor talk about our duty to protect and promote these policies. I just want to reiterate, under this current law that we have now and our policies, it is working. Again, thank you.
Thank you. I'm sorry, what was your last name again?
Todd Renwick, Renwick.
Thanks, Mr. Renwick. Any questions? Yeah, we have one question for you from Ms. Seaman.
Yes.
Thank you, Mr. Chair. Can you answer my question that I had earlier? Because when Mr. Garcia was here, those were the statistics that he gave me.
Yeah, and I'm sorry, and yes, I can answer your question. Our staffing does vary. We have anywhere from 2 to 4 officers on shift. I can tell you today, right now, as I'm up here testifying, we have 5 uniform officers working patrol.
Today?
Right now.
Per approximately 10,000 students, but it can go as low as 2 to 4 per day. Is that correct?
Oh, absolutely, depending on
So my
time of the
data
day,
was
weekend.
correct.
Yes.
Okay, thank you.
No badgering the witness, please. Are there any further questions at this time? Seeing none, thank you very much, officer.
Thank you.
Madam, would you please state your name for the record and proceed?
Yes, my name is Shannon Ellis. I'm the Vice President of Student Services at the University of Nevada, Reno. And in that capacity, I come into contact with prospective and current students and their families on a very frequent basis, as well as the faculty and staff who are there to teach them and to provide the programs and services for their success. I will tell you, when this was in the news last week, I did receive 4 phone calls in my office from the mothers of prospective students who said they would not let their children come to our campus if guns were allowed. I am also at admissions events and have face-to-face conversations. Can I give you numbers? Probably less than 10 parents, and it is parents, who are coming up and asking me about this as a possibility. And it is fear. And that's an overriding theme from what you're hearing from all of us today. It's a fear. There is fear from me for my staff, who are frequently involved in heated conversations with students who are frustrated. They may have mental health issues ranging from I'm frustrated that I'm not doing well in a class to Asperger's and bipolar disorder. A campus environment in this day and age is quite a reflection of the real world in some scary ways. We still adhere to the belief that students learn best at a university level through discourse, dialogue, and disagreement. It can become quite heated. It can be offensive. It can be hurtful. Do I have data? No, but I know that my staff are scared, and we have faculty who are scared as well, that the thought of engaging our students in a conduct situation, a mental health counseling situation, or in a spirited conversation in class, that if someone has a gun, that has a chilling effect at the very least. I do talk to my counterparts at the universities in Utah and Colorado. I talked to them quite a bit before and when these laws went into effect. With all due respect, students in Utah do not drink or drug or party to the extent that our students in Nevada do, and that is from my counterpart there. I will tell you that they have gone to great pains, and I'm happy to get you any data they may have, as has Colorado, to spend quite a bit of time with staff, with recruitment, with what they need to do in their residence halls for students to keep their guns in a safe place. All of these kinds of things have had ramifications. So I am talking to them about the what ifs. I would just add and close with the fact that we all share, no matter how we feel about this bill, that we want our campuses to be safe. And I find that that common ground is very compelling. You are hearing from us that since sexual assaults predominantly happen off our campus and among people who know each other, that please do not look to guns to solve our sexual assault issue on college campuses, because that is not where it is happening in significant and compelling numbers. It is an issue, but this is not the solution. Thank you very much.
Actually, thank you, Ms. Ellis. We're not going to have any questions at this time. We're out of time. Let's go to Clark County. We're going to have one final person testify. Whoever is in the middle down there, state your name for the record, and I'll give you, you get to wrap up the hearing.
My name is Teresa Davis. First and foremost, I am a mother, and I am also on the Southern Nevada Regional Housing Authority Board as a commissioner for the North Las Vegas jurisdiction. I am in opposition of this bill as I have children that are currently students of CCSD. I am a student also at an NSHE campus here. I would not feel safe with my professor being a CCW holder, or my teachers of my students, my children. I work with students and youth who have documented mental and emotional disabilities. So working with those who have those disabilities that are documented, and someone being a CCW holder, should one of my clients have an issue for a day and a CCW permit holder not be aware of that documented disability, feel threatened, I feel that a service would not be done that would be in favor of that youth due to their mental disability that is documented. I just want to say that I am in opposition of this, and I truly wish that this does not, and hope that this does not pass, because I myself, along with other that are here in opposition, we are in fear that those that supposedly would be qualified at the time to be granted the CCW, who's to say that they will continue to be qualified after being permitted to carry these concealed weapons. And Professor Lott stated that currently there may not be any data or or any documentation proving that those that are current CCW holders have committed these acts. Are we going to pass this bill just to get data? And that's my statement. Thank you.
Thank you, Mrs. Davis. All right, well, this time we're actually 5 minutes over on time. We've given equal time to both sides, equal number of witnesses. I'm going to call the bill sponsor back up now at this time to wind up the hearing on Assembly Bill 167. For those of you who are not able to testify, you can put it in writing, send us emails or whatever. We'd love to hear from you, but unfortunately, the volume of people that wish to testify we could probably be here for a week and not get through everybody. Pardon me, it was Assembly Bill 148, not 167. Mixed them up. Well, this is going to be brief, gentlemen and ladies, as in like 2 minutes. Okay.
Thank you, Chair. Thank you, my fellow committee members, for hearing AB 148. I just want to make sure that you understand that everything that I presented to you today is factual. There were a lot of testimony in Clark County that was not factual, nor had data backups, including Mrs. Mastos. Either no facts or wrong facts. I have the facts on the concealed weapons applications on our NSHE campuses. There were 13 concealed weapons permit applications. One was approved. One was approved for a one-day pass. So we have one concealed weapons permit throughout the whole state of Nevada. The other three, when she said that there were 4 approved, the other 3, I want you to understand, it wasn't a concealed weapon that was approved. If I was doing a presentation on, let's say, firearms on one of the NSHE campuses, and I wanted to bring in my acrylic AK-47 lamp, which is a plastic, it's not a firearm, I would have to get permission to go on campus. Just as this necklace that I always wear, they would find offensive as well because it's a firearm. So these are things that we would have to get permission for. So the 3 that was granted permission are things like that. As a legislator, I must tell you that listening to all of your questions and concerns, I definitely disagree with Assemblywoman Diaz that we should imagine things to make up laws. I just don't think that's appropriate. And I'll end with my sentence. And Amanda Collins has said it. Many people have said it. What gives you the right, and how does rendering me defenseless and other students like Amanda Collins protect you from a violent crime? Thank you very much, Chair.
Thank you. And with that, we will end the hearing on Assembly Bill 148. Thanks, everybody, for the good decorum today. Well done. That doesn't end our hearing, however. Whoa, we still have public comment. We actually have some committee introductions to take care of. Then we'll go to public comment. Public comment will be limited very significantly if it has anything to do with the bill that we just heard for 2.5 hours. All right, I do have a bill draft that I need. It's bill draft BDR number 10-1025, repeals provisions governing common interest communities. I'll entertain a motion at this time.
So moved.
Mr. Orenshaw, Mr. Gardner seconds. All those in favor say aye. Aye. Okay, we'll now open up to public comment. If you'd like to, sir, it cannot be in relation to the bill, sir. Okay? Thank you very much. All right, seeing none, nobody else, we will close this hearing.